What? Just let me sign this. After that, mention only the original side matters now. When I take up the appellate side, mention the
Lordship, under compelling circumstances, I am mentioning, Lordship.
Yes.
My lord, the matter is relating to the habeas corpus, Lordship. Missing child is in question, Lordship.
Habeas corpus, I don't have.
Lordship, the determination lies before the Honorable Justice Devanshu Bosak and his companion Justice, Lordship. Subsequently, the determination shifted to the Honorable Justice Mantha, Lordship, because the bench is not sitting, Lordship has been direct. Your Lordship has been with the determination.
I have been given determination of Justice Mantha only.
After 2 p.m., Justice Mantha will sit singly and then after.
কি বলছে? He says, take up urgent notice from the list and determination of division. Justice
Yes,
Mantha.
yes, your Lordship.
Justice Mantha has this habeas corpus was given to Justice Mantha, but
because of the urgent determination.
But it's Justice Bosak
is not sitting till today, Lordship. Yes, that's why, Lordship.
All right, wait, but when shall I take it up?
Lordship,
I take up anytime within the day. I take up original side matters in the morning. 2 p.m. there is a special bench fixed. Then I can fix it at 3.
Lordship.
3:15. Just keep watch, because whenever the division bench, that 3-judge bench is over, I'll sit singly and take up this matter.
Habeas corpus will be taken up by the division bench only, Lordship. Habeas corpus will be taken up by the division
bench. Division bench? Oh, sorry. Then I cannot take up. Today I'm not sitting in division bench.
Lordship.
Right. This is habeas corpus. I was.
The Lordship, leave may be granted to move on Monday, Lordship, on urgent basis, Lordship. Lordship can give the liberty to file and come back on Monday before the regular bench, Lordship, in an urgent basis, Lordship.
I cannot give that leave in sitting singly. That is a difficulty. You better do this. Move the Honorable Chief Justice's, Acting Chief Justice's secretary so that it is assigned to some bench today. Some sitting division bench. Do that immediately. Go to the Chief Justice Secretary whenever the Chief gets time, so that it is assigned. Because I don't sit singly. I don't sit in division bench today at all.
Lordship.
So therefore, this I cannot take up the matter in any event.
Lordship.
Please just get it assigned to some bench. Sorry. Yes. Call on this.
May I mention?
Appellate side.
Milord, in court number 13. Related to court number 13.
13 means Justice?
Justice Kaushik sir.
Justice?
No, Kaushik sir, 13.
Justice
Rajashekhar Mantha, Honorable
Justice Rajashekhar Mantha's single bench. Division bench has been given to me.
Division bench, my lord.
I take up single matters today.
No. I'm just want to take leave to file the this appeal.
Unless I sit in a division bench, I cannot give that leave.
Okay, my lord.
Oh. So have it, file it, I mean, whatever. Yes, call.
Okay.
Call on this.
Thank you.
Passover.
Lordship, I appear for.
Why don't you respond?
Lordship, actually, we're being led by Mr. Pradeep Chindra. He's there in the virtual mode. That's what he communicated to me.
Link do hai Pradeep Chindra ke?
He's there in the lobby, Your Lordship.
Admit to korte hai. আগে থেকে করে রাখতে হতো প্রথম ম্যাটারই আছে আগে থেকে করে রাখো যে লাইনে রয়েছে মিউট করা আছে তো নাকি Yes, Mr. Chinda, sorry.
I'm so sorry, Malaj.
No, sorry for the technical snag. Yes.
No difficulty. I was actually logged in with the previous email with the previous numbers. Perhaps that was the reason why I was not.
No difficulty. So since you're here, then let us start.
Yes, Malaj. Yes. Just give me 1 second, Malaj. I just need to put it.
So আমার আগের নোটস গুলো কি এটার মধ্যে আছে?
Yes. So Malaj, the last occasion.
Yes.
We had completed on our part of the factual submissions.
Right.
Today, Malaj, I will restrict myself, and of course, if there is any clarification required by the bench, I would be more than happy to answer.
Not at this stage. Yes,
Malaj. Yes.
So,
Malaj, I broadly. Malaj,
1 second, Mr. Chinda, yes.
I'm so sorry.
Mr. Bagh wants to say something for the other side. Yes.
Yes.
Junior will be here. May I take Your Lordship?
Yes, absolutely. Yes. Yes. Please continue.
Yes. So, Malaj, this is the case law compilation, which I believe is with the Honorable Court and also has been
Case law
served on the
compilation.
opposite side, Malaj.
লাগবে কেস ল কম্পাইলেশন কোনটা দিচ্ছে Yes, I have.
Malaj. So, Malaj may see the index we have broadly divided. Just to have a look, we have broadly divided the
Yes.
case laws into first part of violation of section 31(2), Malaj, where we say that the award is not signed by all the arbitrators and no reasoning provided.
This is
That-
the way it should be, Mr. Chinda. Thank you for this fine, classification of the.
Yeah. No, Malaj, in
Yes.
fact, I wanted to mention also the paras for the convenience of the court.
Yes, please do that. That
That
will be
unfortunately is not there in the index.
no,
but
just
as
provide me. I'll just take note.
Yes, Malaj. As I go ahead, Malaj, I will
Yes,
provide each on each judgment.
Yes.
I will
You
provide that.
start on each judgment. First, give me the paragraph numbers. I'll take a note and then we'll go into.
Yes, no difficulty, Malaj. No difficulty.
Thank
no
you very
difficulty.
Thank
So the first portion is 31(2), Malaj. Second portion is where we were on the point. I'm just on the second heading in the index. Second, I have merged the two submissions, Malaj, where my argument before the Honorable Court was that the arbitrators cannot rewrite the contract,
Yes.
and also relevant material cannot be left out of consideration.
It's on patent illegality, basically.
Patent illegality, my lords.
Yes.
My lords are very well aware of it. There,
Yes.
my lords, I have put my lords' own judgments
All right.
at serial number 11, 12, 13.
That's
And
the
also-
worst thing to do before this court.
I'm so sorry, my lords.
Because my belief is that we tend to follow our own judgments, and 5 judgments by Justice
No,
Shobhat
my lords, it's only on the
re-added in his own
enunciation.
proposition. So I will look into the other judgments also.
No, my endeavor was only to, Malaj, actually, I could find judgments in the jurisdiction of the Calcutta High Court where my lords were presiding on the
Yes.
point where the legal points have actually been applied on the facts.
All right.
And that is why, that's the endeavor, Malaj. There is no other,
Understood.
there is no other ulterior motive, so to say.
All right. Yes.
Then, Malaj, I have put on the on the third topic, I have put where interpretation can also be perverse.
Yes. All right.
Usually the earlier law was that interpretation of a contract is in the specific domain of the arbitrator, but
Yes.
law has gone about certain change in the recent past. It was
DMRC, I recollect right now, DMRC is on that one.
Yes, Malaj, yes, that,
The
on
other
that
one I
point,
don't
and
know.
also it was carried on from associate builders on itself, but DMRC
Yes.
clarified it.
Right.
Then I am then on the fourth point, Malaj, I've said that fraud vitiates everything. And that is where my first submission was, in fact, that the order is allegedly, Malaj, according to me, the order is fraudulent. Just 1 second, Malaj. There is one. Sorry. Yes, Malaj, that's the aspect of fraud. Malaj, I will seek some more time on the aspect of fraud just to give a few more judgments, but I've just principally I've stated what I wanted to state in this judgment. It's on the enunciation.
That need not multiply judgments unnecessarily.
No,
Basically,
not-
fraud vitiates all is
Yes.
well settled, too well
Yes,
settled to be
yes.
cited
Only
in
on the
judgment.
standard of it, Malaj. I know the other side.
All
The
right.
other side will come. The other side will come with judgments to say that
All right,
look, they have
all
not built that kind of standard in the pleadings in
All
a
right.
section 34 and so on and so forth. It's only on that aspect.
All right.
Otherwise, on the general principle, my lords are very, very clear.
Need not.
Yes. Then on the last aspect, Malaj, I have put interpretation of contract and business efficacy, because one of my arguments is also that look, you can't interpret a contract in a manner, although of course this is in the domain earlier of the arbitrator, but since I am alleging in a section 34 that the interpretation is completely perverse. No third person with similar judicial mind would have reached the same conclusion that the majority award has.
So in a broad manner, this also has a link with section 28 probably.
Yes, Malaj. Yes.
Right.
Yes. 28(3) specifically, where it says you
28(3).
can't, where you cannot go specifically against the provisions of the contract, and also what could have been the interpretation must,
Right.
if at all the court ventures into that aspect, then it has to be a business efficacy understanding.
You
of the
cannot
contract.
interpret out of the contract, basically.
Yes,
I
absolutely. You can't go against the contract
Right.
or contrary to the contract. Now, Malaj, coming to my first point, on the award of section on the award why it is in violation of 31(2) in Dakshin Haryana Bijli. Malaj, please note the paras first.
Yes, please.
Yes, it's para 2, 25, 26, 32, 34, and 35.
Right.
And ultimately, Malaj's conclusion is there in 39 to 46. That's on facts. 39 to 46 is on a dissenting opinion. Malaj, may please also write that.
Very well. Yes.
Yes. Yeah. Now, coming to para 2, Malaj, this is just to show what is the conspectus, what was at issue before the court. It's a slightly different context, but the way the judgment has been written is material for us, Malaj.
Yes.
It says the issue which has arisen for our consideration is as to whether the period of limitation for filing the petition under section 34 would commence from the date on which the draft award dated 27th of April 2018 was circulated at to the parties, or the date on which the signed copy of the award was provided. So this is the conspectus before the court, that whether only a draft award signed by two people could have been the start point of limitation. Now, Malaj, may please have a look at para 25 straight away. This is where, Malaj, the Supreme Court answers that look, 35 is mandatory, and
Yes.
it is not just a procedural provision. I'm reading 25, Malaj, para 13 placitum E.
Yes.
The legal requirement of signing the arbitral award by a sole arbitrator or the members of a tribunal is found in section 31 of the 1996 Act, which provides the form and contents of the arbitral award. 31(1), an arbitral award shall be made in writing and shall be signed by the members of the arbitral tribunal. For the purpose of subsection 1, in arbitral proceedings with more than one arbitrator, the signatures of the majority of all members of the arbitral tribunal shall be sufficient, so long as the reason for any omitted signature is stated. That is where I am basing my submission on, Malaj. Then 4, arbitral award shall state its date and place of arbitration as determined in accordance with section 20, and the award shall be deemed to have been made at that place. 5, after the arbitral award is made, a signed copy shall be delivered. 26, Malaj. Section 31(1) is couched in mandatory terms and provides that an arbitral award shall be in writing and signed by all the members of the arbitral tribunal. If the arbitral tribunal comprises of more than one arbitrator, the award is made when the arbitrators acting together finally express their decision in writing and is authenticated by their signatures. An award takes legal effect only after it is signed by the arbitrators, which gives it authentication. There can be no finality of the award except after it is signed, since signing of the award gives legal effect and validity to it. The making and delivery of the award are different stages of an arbitration proceedings. Stages of the arbitration proceedings. An award is made when it is authenticated by the person who makes it. The statute makes it obligatory for each of the members of the tribunal to sign the award to make it a valid award. The usage of the term shall makes it mandatory requirement. It is not merely a ministerial act or an empty formality which can be dispensed with. Subsection 1 of 31, read with subsection 4, makes it clear that the act contemplates a single date. Now, this is very important, Malaj, and material for our facts. On which the arbitral award is passed, that is the date on which the signed copy of the award is delivered to the parties. Section 31(5). Section 31(5) enjoins upon the arbitrator tribunal to provide, I'm sorry. Yes, to parties. Enjoins on the to provide a copy of the arbitral award to the parties. The receipt of a signed copy of the award is the date from which the period of the limitation starts. So 27 is on that point. Now, Malaj, may straight away come to 32. That is very material for us, Malaj. In an arbitral tribunal comprising of a panel of 3 members, if one of the members gives a dissenting opinion, it must be contemporaneously on the same date as the final award and not on a subsequent date. As the tribunal becomes functus officio upon passing of the final award, the period for rendering the award and dissenting opinion must be within the period prescribed in 29A of the award. In Treatise of the International Commercial Arbitration authored by so-and-so, it has been opined, a dissenting opinion can only be issued when the majority has already made the decision which constitutes the award. Until then, any document issued by the minority can only be treated as a part of the deliberations. However, once the majority decision has been reached, it is preferable for the author of the dissenting opinion to communicate a draft to the other arbitrators so as to enable them to discuss the arguments put forward in it. The award made by the majority could then be issued after the dissenting opinion, or at least after the draft of the dissenting opinion. There is only one date recognized by law. That is the date on which the signed copy of the final award is received by the parties, from which the period of limitation for filing the objections would start ticking. There can be no finality in the award except after it is signed, because signing of the award gives legal effect and finality to the award. The date on which the signed award is provided to the parties is a crucial date in arbitration proceedings. Under the Arbitration and Conciliation Act, it is from this date that period runs. 35.2 is relevant, Malaj. The arbitral proceedings would terminate as provided in 32(1). So therefore, in our case, Malaj, the majority award is dated on 22nd of July 2020. The minority comes only after that, Malaj, 30th. So the problem is therefore, Malaj, that once it becomes functus officio, I have been denuded of the right of the minority to actually give an award, because that award would not be enough. That's the reason why, Malaj, usually judgments when are pronounced, both majority and minority are on the same day, so that both of them are elevated to the aspect of being a judgment of the court. Similarly, Malaj, in a statutory framework of Section 34 of Arbitration and Conciliation Act, it had to be on the same day. So minority, and I had shown to the Honorable Court that minority did not have the copy of the award. There is nothing on record to suggest that it was at the delay of the minority that it happened. Proceeding further, Malaj. 35.2. Now, Malaj, may please straight away come to the relevance at page 18, para 39. And this has been actually discussed recently in a Delhi High Court judgment. I've placed that on record. Page 18, Malaj, may please have a look. Para 39.
Yes.
The dissenting opinion of a minority and arbitrator can be relied upon by the party seeking to set aside award to buttress its submission in the proceedings under Section 34. At the stage of judicial scrutiny by the court under Section 34, the court is not precluded from considering the findings and conclusions of the dissenting opinion of the minority member of the tribunal. In the commentary of Russell on arbitration, the relevance of a dissenting opinion was explained as follows. Any members of the tribunal who does not assent to an award need not sign it, but may set out on his own views of the case, either within the award document or in a separate dissenting opinion. The arbitrator should consider carefully whether there is good reason for expressing his dissent, because a dissenting opinion may encourage a challenge to the award. This is for the party's information only and does not form part of the award, but it may be admissible as evidence in relation to the procedural matters in the event of a challenge, or may add weight to the arguments of a party wishing to appeal against the award. Gary Bond, in his commentary on international commercial arbitration, opines that even absent express authorization in national law or applicable institutional rules, the right to provide a dissenting or separate opinion in an appropriate concomitant of the arbitrator's adjudicative function and the tribunal's related obligation to make a reasoned award. Although there are legal systems where dissenting or separate opinions are either not permitted or not customary, these domestic rules have little application in the context of party-nominated co-arbitrators and diverse tribunals. Indeed, the right of an arbitrator to deliver a dissenting opinion is properly considered as an element of his or her adjudicative mandate, particularly in circumstances where a reasoned award is required. Only clear and explicit prohibition should preclude the making and publication to the parties of a dissenting opinion, which serves an important role in the deliberative process and can provide a valuable check on arbitrary and indefensible decision-making. It is further commented that there is nothing objectionable at all about an arbitrator systematically drawing up a dissenting opinion and insisting that it be communicated to the parties. If an arbitrator believes that the tribunal is making a seriously wrong decision, which cannot fairly be reconciled with the law and the evidentiary record, then he or she may express that view. There is nothing wrong. And on the contrary, much that is right with such a course as part of the adjudicatory process in which the tribunal's conclusion is expressed in a reasoned manner. And if the arbitrator considers that the award's conclusions require a systematic discussion, that is also entirely appropriate. Indeed, it is implied in an adjudicative process that the requirement of a reasoned award. It is further observed that the very concept of a reasoned award by a multi-member tribunal permits a statement of different reasons. If different members of the tribunal in fact hold different views, this is an essential aspect of the process by which the parties have an opportunity to both present their case and hear the reasons for the tribunal's decisions. Not hearing the dissent deprives the parties of an important aspect of this process. In Sangyong, this court upheld the view taken in dissenting opinion to be the correct position in law. In this case, the court was hearing a special leave petition from an order passed by a division bench of the Delhi High Court. This court noted a Section 34 petition which was filed by the appellant was rejected by the learned single judge of the Delhi High Court by a judgment and order dated so-and-so, in which it was held that a possible view was taken by the majority arbitrators, which therefore could not be interfered with, given the parameters of challenge to the arbitral award. The learned single judge also went on to hold that the new series published by the ministry could be applied in the case of the appellant as the base indices for 2004-5 under the new series were available. Having so held, the learned single judge stated that even though the view expressed in the dissenting award is more appealing and that he preferred that view, yet he found that since the majority award is a possible view, the scope of interference being limited, the Section 34 petition was dismissed. A Section 37 appeal by the division bench of the Delhi High Court yielded the same result by the impugned judgment dated 3/4/2017. This court set aside the award. However, in para 77 of the judgment, the court held as under. The judgments of the single judge and of the division bench of the Delhi High Court are set aside. Consequently, the majority award is also set aside. Under the scheme of Section 34, the disputes that were decided by the majority award would have to be referred afresh to another arbitration. This would cause considerable delay and be contrary to one of the important objectives of the 1996 Act, namely speedy resolution of disputes by the arbitral process under the Act. Therefore, in order to do complete justice between the parties, invoking our power under Article 142 of the Constitution of India, and given the fact that there is a minority award which awards the appellant its claim based upon the formula mentioned in the agreement between the parties, we uphold the minority award and state that it is this award, together with interest, that will now be executed between the parties. The minority award in paras 11 and 12 state as follows. I therefore award the claim of the claimant in full costs, no amount is awarded to so-and-so. In Sangyong, this court upheld the view taken by the dissenting arbitrator in exercise of its powers under Article 142 of the Constitution in order to do complete justice between the parties. The reasons for doing so is mentioned in para 77, that is considerable delay which would be caused if another arbitration was to be held. This court exercised its extraordinary power in Sangyong, keeping in mind the facts of the case and the object of expeditious resolution of disputes under the arbitration. In law, where the court set aside the award passed by the majority members of the tribunal, the underlying disputes would require to be decided afresh in an appropriate proceedings under Section 34, the Court of the Arbitration Act. The court may either dismiss the objection filed and uphold the award or set aside the award if the grounds in subsection 2 and 2A are made out. There is no power to modify. This, of course, Malas, have undergone change after Gayatri Balasamy Malas, that now the courts can
Yes.
modify. So
But
I
to a
will not
limited
rely on
extent.
what-
To a very limited extent.
to a very limited extent, but they can.
Yes.
Earlier, the idea was that not even interest can be gone into.
Cannot
but
be
now, of
touched.
course-
Yes.
Yes. Now at least that avenue has been opened, Malas.
Yes.
Para 45, applying the law to the facts of the present case, we find that from a premisal. Now, this I will just read 45 because that is peculiar to the facts as to what happened in that matter. Applying the law to the facts of the present case, we find from a perusal of the arbitral proceedings that even though the award was pronounced on 27th of April, the signed copy of the award was provided to the parties only on 19th of May, 2018. The procedural orders of the tribunal reveal that on 27th of April, only a copy of the award was provided to the parties to point out any computation error, any clerical or typographical error, or any other error of similar nature, which may have occurred in the award on the next date. Sorry. Or similar nature, which may have
The
occurred.
rest need not be read, Mr.
Yes, Manas. So 40. So point that I'm trying to make from the judgment is
Yes.
that it is not just a clerical requirement, it is mandatory, and what is the importance of a minority award.
Right.
And in fact, Manas, in this case, it's peculiar because in our matter, minority comes later. So in law, if the tribunal became functus officio on 22nd of July, I am deprived of that minority award, Manas, which would have come on 22nd of July 2020. Had the deliberative process happened between the arbitrators.
Yes.
But it is clear on facts, Manas, I have demonstrated that in the minority award itself, it is written that there was no copy provided and he was just informed, and that too, that the claims have been allowed. That is it.
Yes, I
No.
recollect that. I recollect.
Yes.
Yes.
That's right, Malaj. Now, coming to the second judgment, Malaj, ISC. Malaj, may please note the paras first.
Yes.
It's paras 8, 12, 16, 19,
Yes.
27, 28, 31 to 34.
Right.
Now, Malaj, may please have a look at para 8 first as to how the matter came up.
Yes.
And this is a matter, Malaj, squarely on the point where the award has been set aside on the point that it was not signed by one of the arbitrators. Malaj, may please have a look at para 8 first.
Yes.
The impugned award is dated 12th of March 2020 as filed before this court. It contains two parts. The first part is an award of 50 pages signed only by arbitrator B. The claims of the petitioner have been dismissed and the counterclaims of the respondent have been allowed to the extent of 5 crore 83 lakhs 10,000 so and so. The second part of the award is a single page award signed by the presiding arbitrator. It states that the presiding arbitrator has gone through the award written by arbitrator B and that he is in agreement with the findings recorded and orders passed by him. The operative portion of the award signed by the arbitrator has been reproduced. Now, Malaj, may please see para 12.
Yes.
Yes. When the petition was instituted before this court, the respondent first took an objection as to the territorial so-and-so by an order dated so-and-so execution of the impugned award was stayed, subject to the petitioner depositing an amount. By an order dated so-and-so, the petitioner was permitted to furnish a bank guarantee. This is fine. Please have a look at 16. Now, so third arbitrator, this is an email by the presiding arbitrator with copies to arbitrator B and C. Now, please have a look there. By an email dated so-and-so addressed to the presiding arbitrator and copied to arbitrator B, an official of the scope, arbitrator A stated as follows. An award written by arbitrator B was received by me today in the morning at 11:30. The case was heard somewhere in September, and after that, there were no meetings amongst the three arbitrators regarding the course of action to be taken. As I understand from our telephonic conversation and so, for giving the award on 15th of February 2020, whereas an official of the scope who called me today told me that the last date of giving the award is 13th of March. You had received the award from the arbitrator B on 8th or 9th of March 2020. The award written by arbitrator B, duly signed by you, endorsing the same, has been sent by you to the scope. You had called upon telephone on the 9th and 10th of March, informing me that a copy of the award was sent to me, but I did not receive the same till yesterday. On 12th March 2020, you rang me up again around 6 o'clock and in the evening to know my views on the award, and I informed you that I had not received the copy of the award. You have now sent me a copy of the award today in the morning. I substantially do not agree with the award written by the arbitrator B, and it is impossible for me to write my opinion in this short period. I would request you, being the presiding arbitrator, to ask the parties to get the time extended to enable me to write my opinion. I find it very strange that arbitrator B did not choose to send the copy of the award written by him to me. Arbitrator B did not deem it fit to circulate the award to both the arbitrators and sent it only to the presiding arbitrator for opinion. You have agreed with the opinion written by the arbitrator B and sent it to the scope. Under circumstances, it is a fait accompli, as you both have already agreed and sent a signed copy of the award to the scope without consulting or sending a copy of the award to me. If you are not prepared to ask the parties to get the date extended, then let the proposed award being majority opinion be published along with the present dissenting note of mine recording the sequence of events and my dissent. Though I would like to express my views in detail, as we had dealt with the case on more than 20 hearings, I still leave it to your discretion to deal with the matter as per law and as the situation so warrants. I am sending a copy of this letter as well to the scope. 70. The second email was addressed by arbitrator A to scope on 18th of May. So this was Mala's 13th of March. This email that my lords read is 13th of March. On 18th of May, the arbitrator A writes to scope, dear so-and-so, in the above noted case, award has been written by arbitrator B, one of the arbitrators. On 13th of March, I sent an email to the presiding arbitrator disagreeing with the proposed award. Proposed award 2 could not write the award as the time was for pronouncing the award was to expire on the next day. Presiding arbitrator wrote back to me that he is not going to ask for further extension and he is announcing the award by majority. Accordingly, the award was announced. You already have a photocopy of my cancelled check of so-and-so. Now, para 19. Learned counsel for both the parties have cited the following provisions of the Act. Section 29, decision making by a panel of arbitrators. Unless otherwise agreed by the parties in arbitral proceedings with more than one arbitrator, any decision of the arbitral tribunal shall be made by the majority of all its members. Notwithstanding subsection 1, if authorized by the parties or all members of the arbitral tribunal, questions of procedure may be decided by the presiding arbitrator. 31. An arbitral award shall be made in writing and shall be signed by both the parties. My lords have already seen 31.1 and 31.2.
Yes, yes.
I'm not going to read that.
No.
Now, my lords may please come straight away to analysis on the next page, page 28, para 27.
Yes.
The above quoted provisions of the Act have been considered in several decisions of the courts, including the judgment of the Supreme Court in Dakshin Haryana Bijli Vitran Nigam, which my lords have just read. The court held that in the case of a multi-member tribunal, only a unanimous award or a majority award is an award of the tribunal. A dissenting opinion is not an award at all. However, it was also held that all members of the tribunal should have signed the award and that a dissenting opinion, if any, must be delivered contemporaneously with the majority award. For the present purpose, para 26 is of relevance, which reads as follows. 31.1 couched in, my lords have already seen 26.
Yes, this has been,
Yes,
already.
yes. My lords may now look at para 28 straight away. This is only a reproduction of the earlier. That's why I'm not reading it. 28, my lords may look at.
Yes.
Although the opinion of a dissenting arbitrator has been characterized only as an opinion and not an award, the court has emphasized that both must be issued at the same time.
This is also a repetition, Mr. Chindra, you have already read from Sangyang. So
Yes.
let us move on to 31.
Yes, yes. My lords may now please come to straight away para 29.
29 also? You said 31.
No,
Yes.
para 29 is some other judgments, my lords.
Acha, acha.
Yes.
So on the same point must be, yes.
Same point, but different courts.
No difficulty. You can come to the finding of Justice Jalan directly.
Okay. My lords may then come to straight away para 31.
Yes.
From the aforesaid judgments, the following basic principle relevant to the adjudication of the present case emerge. It is the award of majority alone that constitutes an arbitral award. The opinion of a dissenting arbitrator is not an award at all. Signatures of all members of the arbitral tribunal should be available on the award. The signing of an award is not a ministerial act, but a substantive requirement. If the signature of any member of the tribunal is omitted, the reason should be stated. However, the reason can be supplied separately and subsequently. The requirement is referable to the need to ensure that all members of the tribunal have had an opportunity to participate in the decision-making process. This requires the court to consider the reasons apparent from the record to satisfy itself that the reasons are relevant, germane, and adequate. While a dissenting opinion has no direct legal effect, it is also not wholly meaningless or irrelevant. The expression of a dissent is part of the adjudicative mandate of the arbitrator. It forms part of the duty to give reasons, which is enshrined in the Act, constitutes a safeguard against arbitrary and unchecked decision-making, and can be used by the aggrieved party as well as the court in the course of a challenge to the majority award. 32. These principles must be applied to the undisputed facts of the case. The signature of arbitrator A does not appear on the award. The impugned award does not disclose any reason for the fact that the signature of arbitrator A was missing. There is no separate dissenting award circulated by him. The question, therefore, is whether the reasons for missing signature have been disclosed at all, and if so, whether they are relevant, germane, or adequate. Conversely, if the reasons show that all three arbitrators have not had the opportunity to participate in the decision-making process fully and equally, such reasons would not be acceptable to justify the missing signatures.
Yes.
In order to consider reasons available on record, albeit supplied later, I have examined the correspondence between the arbitrators inter se and with scope, and I am of the view that the petitioner's argument must prevail for the following reasons. Arbitrator A, in his email dated 13th of March 2020, addressed to both the other arbitrators, states that there were deliberations between arbitrator B and presiding arbitrator, to which arbitrator A was not a party. In fact, the two other arbitrators had sent this award to scope before it had even reached arbitrator A. The contents of the said email have not been controverted by either of the other arbitrators or by scope. This shows that arbitrator A was not invited to participate in the deliberation of the tribunal at the stage of the final decision making. The draft award was sent to arbitrator A only on the eve of expiry of the mandate of the tribunal. Arbitrator A suggested requesting the parties to approach the court for an extension, but that too was declined. He was therefore unable to prepare and present his detailed dissent. An attempt was made on behalf of the respondent to submit that the arbitrator A ought to have prepared his own award within the period of the tribunal's mandate or even thereafter. The judgment of the Supreme Court in Dakshin Haryana, however, indicates that a minority view can be formulated only after the majority view is known. In any event, I do not find any support for the suggestion that the arbitrator A was required or bound to prepare his opinion in anticipation of the opinion circulated by the other arbitrators. In all the cases cited on behalf of the respondent, where a majority award has been upheld despite a missing signature, either the reason for the missing signature have been found to be satisfactory or time was given to the dissenting arbitrator to prepare his dissent, but he failed to do so. The facts of the present case fall, in my view, on the other side of the line, where one of the three arbitrators was excluded from the final consultation process and was also not given the opportunity to publish a dissenting award. The purpose of a multi-member tribunal comprising of appointees of each party, as provided under 11(3) of the Act, is for the constitution of a tribunal which is in accord with the consent of the parties. Party autonomy and adjudication by a consensually appointed tribunal are intertwined. The Act recognizes the concept of the party-appointed arbitrators, which is reflected in the arbitration clause in the present contract also. A party is entitled to the assurance that the arbitrator nominated by it will have a seat at the table when the fate of the litigation is decided. However, the court has to be careful to ensure that a recalcitrant or obstructive minority arbitrator cannot hold the proceedings to ransom by refusing to sign the award. If at all any arbitrator refuses to participate in the process or otherwise obstructs the making of the award, the situation would be different. But there is nothing in the present case to suggest such conduct on the part of arbitrator A. In fact, the learned counsel for the respondent also did not invite an inference of this nature. The balance between the two competing considerations has been struck in the statute itself, when it provides that an award signed by the majority shall be valid, but that reasons for the omission of any signature must be stated. For the aforesaid reasons, I do not find the procedure followed in this case to inspire confidence. I am therefore of the view that the impugned award is liable to be set aside on the first ground urged by the petitioner. I appreciate that this entails another round of arbitral proceedings, but considerations of expediency and convenience cannot, in my view, override principles of fairness and procedural integrity, which must underpin arbitral adjudication. As noted above, the petitioner's suggestion that the matter may be sent for re-adjudication only at the stage of final hearing was not accepted by the respondent. Unfortunately, both parties must bear the consequences. So that's the kind of consideration the court also gave in a 34 while going into the question. Now, Malaj, may please have a look at the next judgment. It's a very old judgment, Malaj. 1916, Calcutta. But why I'm citing it and what it underlines is this, Malaj. It says that even at the final stage, irrespective that you may have participated during the proceedings, you may be a member, you may be sitting for all the hearings, but if you at the final stage of making the award not consulted, then even then the process is vitiated. It's only a 2-page judgment, Malaj, page 38 and 39. The relevant, unfortunately, doesn't have paragraph numbers, Malaj, but Malaj can see on the first page 38.
Yes.
I am just reading from the bottom. It's the fact I'm just reading from the bottom.
Yes.
From the bottom, I am reading, Malaj, about the 12th line from the bottom, Malaj. It says, to that, no objection by any of us will be entertained.
Yes. Got it.
Under this instrument, 5 gentlemen were appointed arbitrators, 3 of whom alone signed the award. The application with which we are now concerned was made for the enforcement of this award. The defendant objected that there was no valid award in law because 2 of the arbitrators had not attended all the sittings and 1 at least did not take part in the final deliberations. The plaintiff contended that inasmuch as the 3 arbitrators who had made the award had attended all the meetings, and as a majority of the arbitrator was competent to make a valid award, the award was legal and enforceable. The subordinate judge has overruled these contentions on the ground that all the arbitrators should be present at all the meetings, and particularly at the last, when the final act of arbitration is done, though as a result of this united deliberation, there may be an award by the majority of only few of them. It should be only of them. In our opinion, the view taken by the subordinate judge is correct. Now, Malaj, may please straight away skip to their reasoning. I'm reading just beneath page 303. It says page 303. There is a perforation line, Malaj.
Yes,
in the
yes.
mid-
Right,
yes,
right.
and it says page 303.
Yes,
I'm reading fourth line from that top. The principle which underlines the view.
yes, very, yes.
The principle which underlies the view we take is best stated in the words of Russell, which have now become classical, quoted as they were with approval in Beck versus Jackson and Khela Chandra Ghosh versus Tara Chand Kundu, as as the arbitrators must all act, so must they all act together. They must each be present at every meeting, and the witnesses and the parties must be examined in the presence of them all. All the parties are entitled to have recourse to the argument, experience, and judgment of each arbitrator at every stage of the proceedings, brought to bear on the minds of his fellow judges, so that by conference they shall mutually assist each other in arriving at a just decision. The same point of view had been emphasized in Daling versus Matchett, where the Court of Common Pleas observed as follows. It has often been said that if that one had been present, that is, the arbitrator who did not attend, he could not by his vote have turned the majority the other way, when all the rest were unanimous. Yet it has always received this answer that everyone has a right to argue and debate as well as to give his vote, and it is possible at least that the person absent may, if he had been present at the meeting, have made use of such argument as may have brought over the majority of the rest to be of his opinion. The matter was put substantially in the same way in
Have you seen, Mr. Chandra, have you seen 12 Angry Men?
I'm sorry, Malaj?
12 Angry Men, have you seen?
Yes, Malaj, I've seen the movie. Yes.
So this is the principle.
Yeah.
One could turn around the others.
Absolutely, Malaj. Absolutely. Any two under. So the matter was put substantially in the same way in Ray Bering. Lord Denman observed, any two under such submission as this, that is, a submission which provides for a valid award by the majority, may make a good award. But then it must be after discussion with the other arbitrators. If after discussion it appears that there is no chance of agreement with one of the arbitrators, the others may indeed proceed without him. Coleridge just added, the parties have not got what they stipulated for. They stipulated that two at least should make the award, but no two could make it till each arbitrator has been consulted. This view accords with that adopted in so-and-so judgments. We adopt the principle that inasmuch as the parties to the submission have the right to the presence and the effect of the arguments, experience and judgment of each arbitrator at every stage of the proceedings, so that by conference they may mutually assist each other in arriving at a just conclusion. It is essential that these should be a unanimous participation by the arbitrators in consulting and deliberating upon the award to be made. The operation of this rule is in no way affected by the fact that authority is conferred upon the arbitrators to make a majority award. Even where less than the whole number of arbitrators may make a valid award, they cannot do so without consulting the other arbitrators. The inference follows that in the present case, there is no valid award. So it's only, Malaj, for the enunciation that I pointed the night. Although, of course, this is a judgment much prior to the 96 Act, but the principle remains the same, Malaj, be it this Act 1940 or 1996. Now, Malaj, may please come to the next judgment of Maharashtra State Electricity versus Deltron Electronics. This is a Bombay High Court, Malaj, and the relevant paras are only 5 and 6. Malaj, may have a look at first para 3. What is at issue? It's a short para, Malaj, at page 45.
Right, got it.
As submitted by the learned counsel for the petitioners, the challenge to the award is mainly on 3 grounds. Firstly, it is submitted that the award is not signed by the chairperson of the council, who sat as one of the arbitrators. There is no material to show that he actually participated in the deliberations of the arbitral tribunal, stroke council, for making of the award, or agreed or even considering its findings, and that in the premises, the award cannot be termed as a valid arbitral award. This is what we are concerned with, Malaj. I'm not reading second and third. Now, Malaj, may please have a look straight away to para 5.
Right, 5.
Coming now, it's at page 46, 5. Coming now to the first ground of challenge to the impugned award raised by the petitioners, subsection 1 of 31 of the Arbitration and Conciliation Act requires the arbitral award to be made in writing and signed by the members of the tribunal. Subsection 2 of Section 31 provides that for the purpose of subsection 1, signatures of the majority of the members of the arbitral tribunal shall be sufficient so long as the reason for any omitted signature is stated. As held by the number of our high courts, an award signed by a majority of the arbitrator is valid, provided all arbitrators were present through the proceedings and took part in all deliberations, including deliberations for preparation of the award. This is important, Manoj, because
Yes.
I'm sure in their written submissions they'll come up with an argument that, look, it doesn't really matter at the time of final hearing. He was present all throughout.
Right.
Now, Manoj, may please see para 6. If one has regard to the impugned award in the present case, what transpires in the first place is that there is nothing in the award or the subsequent orders of the Arbitral Tribunal Council to indicate that the chairman of the Arbitral Tribunal Council was available and actually participated in the deliberations of the council for making the award. The award itself is dated 31st of January 2015. It, however, appears from the award that at least 2 members of the Arbitral Tribunal Council who have appended their signatures to the award have signed the same after 31st of January 2016. On the other hand, the minutes of the meeting dated 5th of September 2015 take a position that the award was passed on 8th of May 2015. The award itself indicates the matter was closed for award on 31st of January 2015. It is hardly likely in the premises that the award was actually made on 31st of January 2015. In any event, as the subsequent communication indicates, it is the stand of the Arbitral Tribunal Council itself that the award was passed on 8th of May 2015. It is not borne out by the record as to when the chairman of the Arbitral Tribunal Council was transferred. There is absolutely nothing, either in the award or in the communication as mentioned above, to indicate that after the matter was closed for order/award, the chairman of the Arbitration Tribunal Council participated in the deliberations or assented or even applied his mind to the impugned award. No doubt, under the scheme of the Arbitration and Conciliation Act, the award within the meaning of the Act is really an award of the majority of the arbitral tribunal, and the award of any dissenting minority is no award. That still does not dispense with the requirement of participation of all the arbitrators in reference and in the deliberations for making of the award. Subsection 2 of 31 of the Arbitration and Conciliation Act requires that if the award is not signed by all members of the arbitral tribunal, the reason for omitted signatures must be stated. As we have noted the law on the point, what this means is that not just that the reason must be stated mechanically and as a matter of form, but that such reason must be adequate and germane for fulfillment of the requirement of the law, that though the arbitrators whose signatures are omitted actually participated in the hearings and the deliberations for making of the award, their signatures are justifiably not appended to the award. The justifiable reason may be absence or unavailability of the arbitrators at the time of signing, which is merely a ministerial act, or his or their refusal on the ground of any dissension or disagreement with the majority or the like. As I have noted above, such adequate and germane reason is clearly absent in the present case. In the premises, the impugned award cannot be termed as a valid award in the eyes of law. The want of signature of the chairman of the Arbitral Tribunal Council cannot be attributed simply to any administrative exigency or ministerial lapse or difficulty, or even his having taken a dissenting view. It rather goes to the root of the award and undermine its validity. Then he
Right.
goes into fact. We are not going into facts.
No.
Now Malaj may look at this is the judgment of the Delhi High Court, Mahanagar Telephone. The relevant paras are Malaj 4, 10, 15, 17. I'm sorry,
14, 15, 17, yes.
20 and 21.
Thank you. 20?
20
Sorry.
and 21.
20 and 20. Right.
21. Yes.
Thank you. Yes.
Malaj, please look at straight away para 4.
Yes, please.
Parties led documentary and oral evidence and on a consideration of the same and hearing the submission of both sides, the arbitral tribunal made its award. The 2 arbitrators, namely Mr. Justice Kanya and Mr. Justice Khanna, made a joint undated award sometimes towards the end of August 2000, while Justice Srivastava made a separate dissenting award dated 28/11/2000. While a communication dated 1/12/2000, the Indian Council of Arbitration forwarded the undated majority award, the minority dissenting award of Mr. Justice Srivastava dated 28/12/2000, the note and the correspondence exchange amongst the arbitrators, and a note of Justice Khanna mentioning therein that the award constituted of the composite papers, all of which comprised and constitutes an integral part of the award. Via further communication dated 12th of January 2001, the Indian Council of Arbitration furnished the schedule containing the details of the awarded amount, signed by Justice D.R. Khanna, and via another communication letter dated so-and-so, ICA forwarded Schedule B containing the details of the arbitration cost. Now, Malak, may please look straight away to Para 10.
Yes.
In the case in hand, now this is one of the arguments, Malak, actually of a council. Finding starts from 15, but I'll just read Para 10 for a minute.
Yes.
In the case in hand, the award is signed only by two arbitrators, and the reason for not affixing the signature of the third arbitrator has not been stated. The so-called award of the majority also does not contain the date. Therefore, the important question is as to whether the so-called award of the majority meets the requirement of the award or not. The definition of the arbitral award appearing in Section 21C of the Act simply states that the arbitral award includes an interim award, and therefore it is not of much help to determine this question. In support of his contention that the so-called majority award is not an award within the meaning of Section 31, Mr. Bhatt has placed reliance on the Supreme Court judgment in ONGC and SAW pipes. In that case, the Supreme Court had the occasion to more fully consider the grounds on which the court can set aside the arbitral award under Section 34(2), and in that context, it has focused its attention as to when an award can be said to have been made in accordance with Part 1 of the Act, and when it can be said to be in conflict with the public policy of India. In Para 5, 11, 12, and 15 of such judgment, the Apex Court held that an award which does not comply with Section 32 will be illegal and liable to be set aside on so-and-so. I'm not going into this detail, Malak. Now, please come straight away to Para 15. In the case, Para 16 at page 61.
Yes, got it.
Yeah. In the case in hand, as noticed at the threshold, the so-called majority award is an. Can I just have some water, Malak?
Oh, please do.
Yes. Coming back to Para 15, Malak, at page 61.
Yes.
In the case in hand, I noticed at the threshold, the so-called majority award is an undated award, and it does not give out the reasons for the omitted signature of the third arbitrator, namely Justice Srivastava. The non-dating of the award by the two arbitrators does not appear to be due to any inadvertence or for reasons suggested by Mr. Jaitley that the third arbitrator had not rendered his award by the date the two arbitrators made their award. Rather, it appears for the reasons which are not difficult to understand. From a perusal of the record of the arbitral proceedings brought on record and the correspondence notes exchanged amongst the arbitrators, it would appear that even though Justice Khanna were not clear as on what date the document said to be termed as majority award was signed by the two members, the letter of Justice Khanna, dated 12 September 2000, addressed to Justice Khanna, would indicate that both of them signed the award on 27th of August 2000. It is pertinent to note that before the said date, Justice Khanna had written to Justice Kanya on 25th of August 2000 in regard to the note sent by Justice Srivastava, clearly stating that he deemed the document as a proposed award. Then Para 17, straight away. From the sequence of events which took place in the later part of August 2000, it is clear that there had not been any effective deliberation amongst the three arbitrators, and no consensus could be reached as to the proposed award. It appears that at the later crucial stage, the deliberations were confined between the two arbitrators, namely Justice Kanya and Justice Khanna only. After such deliberations, they had prepared a draft of the award for the perusal and consideration of the third arbitrator, namely Justice Srivastava. The said draft of the award was also signed by Justice Khanna and Justice Kanya in anticipation of its approval or concurrence by Justice Srivastava, because Justice Khanna was proceeding abroad and Justice Kanya was staying in so-and-so was to return to Bombay. From the tenor of the note of Justice Srivastava and that of Justice Khanna, dated so-and-so, it is apparent that they treated the so-called award as the proposed formative award. Merely because the proposed draft came to be signed by the two arbitrators will not alter the nature of the document and convert it into an award within the meaning of the term, because it is the intention of the arbitrator which has to be seen, rather than going by a mere coincidence of the draft award bearing the signature of the two arbitrators. On the face of the facts and circumstances of the case, there was no question of the theory of the two arbitrators having become a functus officio soon after signing of the award being attracted, because Justice Khanna, though signatory to the document, treated the said document as a draft award or proposed award. As per Justice Khanna, the document which he forwarded to Justice Srivastava was a proposed draft which had been prepared without any deliberations with Justice Srivastava in anticipation of his approval. Justice Khanna reiterated this position even in his last note, but under certain erroneous belief, wrote a note where he stuck to his earlier view that the award for a sum of rupees 91 lakhs with interest towards DDF was not justified, but once he has signed the award, he felt helpless in the matter. It is not uncommon for the authors of certain orders documents to sign or initial the draft of the document so as to make it authentic draft emanating from a particular person. This incidence alone cannot be used to term the draft as a final award. It is the intention of the author coupled with the circumstances which needs to be taken into account. On a consideration of the matter, this court is still at a loss to pinpoint the exact date of the majority award. The above noted circumstances would lend credit to the theory that the document purported to be a majority award was not a final award of the two members of the tribunal, but it was only draft of the award or a formative award. The correspondence exchange between three arbitrators clearly points out that Justice Khanna was convinced of the reasons given by Justice Srivastava in regard to the award for a sum of rupees 91 lakhs with interest of 18% from 28th of June 95, because it appears that the three arbitrators on a deliberation have already taken a view in para 22 of the award that the respondent had not filed any claim in regard to the price of DDF in the claim petition, which appeared to be an afterthought, and therefore separate claim towards the said items were unsustainable. Strangely enough, and unfortunately, Justice Khanna endorsed the view of Justice Kanya in regard to, or for that reason, the two arbitrators having become functus officio after signing the award in view of Supreme Court decision in the case of Satwan Singh Sodhi and so on so. Taking into account the totality of facts and circumstances and the material brought on record and the manner in which the arbitral proceedings were conducted by the two arbitrators at the stage of making of the award, this court has no hesitation in holding that the document purported to be a majority award cannot be termed as an award within the meaning of the term of the Act. And it is violative of Section 31(2) and Section 31(4) of the Act and hit by the provisions of 34(2)(a)(5) of the Act. The award is therefore liable to be set aside on this ground alone. Then Maloj may come to the last judgment on this point. It's a Gujarat High Court judgment of a DB Maloj. Just two paragraphs, not much. Page 67, Maloj.
Yes.
These are paragraphs 18 and 19.
Right.
Para 18, Maloj, at page 82.
Yes, got it.
Maloj. After the discussion on the on the merits of the matter, this is just on one portion that the court refers to. It says there is one infirmity we have noticed in the arbitral award. The arbitral award has not been signed by the arbitrator. This fact is not in dispute. The statute makes it obligatory for each of the members of the tribunal to sign the award so as to make it a valid award. The word shall in Section 31 of the 1996 Act makes it a mandatory requirement. Para 19 is Dakshin Haryana Bijli Vitran Malaj. I'm not going to read it. Malaj, I've already looked at it in para 19. Then at para 20, at page 87, he sets it aside on that ground as well.
Yes.
In the result, this appeal succeeds and is hereby allowed. The impugned judgment and order passed by the court below is hereby quashed and set aside. Consequently, the connected civil application stands disposed of. Now, Malaj, this completes our submission on Section 31(2), Malaj.
Yes.
The two primary judgments being put right at the beginning, Malaj. The Supreme Court and the Delhi High Court, which considers everything. And of course, the Calcutta High Court of 1916 for the principle of it. Now, Malaj, may please turn to the next heading. That where Malaj are very well versed of the heading it will not take us longer because I've already considered this, and these are all points which have already been considered, which usually come in a section 34.
Right.
First judgment, associate builders. Maharaj may note the paragraphs 27 to 33, 32 and 42 to 44.
Yes.
Para 27 starts at page 113, Maharaj.
Yes. Got it.
Coming to each of the heads contained in saw pipes judgment, para 27, page 113, Maharaj.
Got it. Yes.
Placetum D.
Right.
Coming to each of the heads contained in saw pipes judgment, we will first deal with the head of fundamental policy of Indian law. It has already been seen from Renu Sagar judgment that the violation of Foreign Exchange Act and the disregarding orders of superior courts in India would be regarded as being contrary to fundamental policy of Indian law. To this, it could be added that the binding effect of the judgment of superior court being disregarded would be equally violative of the fundamental policy of Indian law. In a recent judgment of ONGC, this court added 3 other distinct and fundamental juristic principles which must be understood as a part and parcel of fundamental policy of Indian law. The court held what then would constitute fundamental policy of Indian law is the question. The decision in ONGC does not elaborate that aspect. Even so, the expression must, in our opinion, include all such fundamental principles as providing a basis for administration of justice and enforcement of law in this country. Without meaning to exhaustively enumerate the purport of the expression fundamental policy of Indian law, we may refer to 3 distinct and fundamental juristic principles that must necessarily be understood as part and parcel of the fundamental policy of Indian law. The first and foremost is the principle that in every determination, whether by a court or other authority that affects the rights of a citizen or leads to any civil consequences, the court or authority concerned is bound to adopt what is in legal parlance called the judicial approach in the matter. The duty to adopt a judicial approach arises from the very nature of the power exercised by the court or the authority does not have to separately or additionally enjoined upon the fora concerned. What must be remembered is that the importance of a judicial approach in the judicial and quasi-judicial determination lies in the fact that so long as the court, tribunal, or the authority exercising powers that affects the rights or obligations of the parties before them shows fidelity to judicial approach, they cannot act in an arbitrary, capricious, or whimsical manner. Judicial approach ensures that the authority acts bona fide and deals with the subject in a fair, reasonable, and objective manner, and that its decision is not actuated by any extraneous considerations. Judicial approach in that sense acts as a check against flaws and faults that can render the decision of a court, tribunal, and authority vulnerable to challenge. Equally important and indeed fundamental to policy of Indian law is the principle that
why are you reading these paragraphs? Because these are judicial approach, audio alternate party, and Wednesbury principle.
Yes, Maharaj. So
these are settled. Yes.
Yes. 31
How is
and
it relevant in the context? Yes.
Yes, please have a look at 31. I'm just setting the context for 31.
All right. So let us come to 31 directly.
No difficulty, Maharaj. No difficulty. Because one of the pillars of judicial approach is now defined in 31.
Right.
Please have a look at that. The third juristic principle is that a decision, it's at page 115.
Yes, got it.
Yes, the third juristic principle is that decision which is perverse or so irrational that no reasonable person would have arrived at the same is important and requires some degree of explanation. It is settled law that where finding is based on no evidence or an arbitral tribunal takes into account something irrelevant to the decision which it arrives at or ignores vital evidence in arriving at its decision, such decision would necessarily be perverse. So in our case,
no evidence, irrelevant evidence, and
correct.
Evidence but not considered.
Correct. So in our case, Maharaj, I was saying that in cases of electricity, for the damages which have been awarded for electricity as well as for consumption of diesel, I am stating that the evidence that was on record is no evidence at all because people who appeared before the tribunal abandoned those documents.
All right.
Number 1. Number 2, they were not backed by any other material documents. One is a ledger. The ledger has no underlying. When they were questioned, they have no basis. They just say that we may have, but they don't produce anything.
Yes.
So that is where when I argued on facts, that was my legal submission. I'm just making that good by stating that those aspects according to me, are covered under 31 and 32 of the associate builders.
True.
Now, coming to Madhav's 32,
Hmm.
a good working test of perversity is contained in two judgments of excise and taxation, Gopi, so and so. It is no doubt true that if a finding of fact is arrived at by ignoring or excluding relevant material, or by taking into consideration irrelevant material, or if finding so outrageously defies logic as to suffer from vice of irrationality, incurring the blame of being perverse, then the finding is rendered infirm in law. This also permeates to my submission of section to the clause 14, that I am saying that clause 14, where it requires two legs of warranty, namely 12 months or 24 months, you don't consider the second part of it at all.
All right.
That's where I'm also trying to apply to it. In Kuldeep Singh versus Commissioner of Police, a broad distinction has therefore to be maintained between the decisions which are perverse and those which are not. If a decision is arrived at on no evidence, or evidence which is so thoroughly unreliable. I'm reading at Placitum A. Malad.
Yes, I'm reading that.
Yes. And no reasonable person would act upon it. The order would be perverse. But if there is some evidence on record which is acceptable and which could be relied upon, howsoever compendious it may be, the conclusions would not be treated as perverse and the findings would not be interfered with. That's okay, Malad. That's the general.
Somewhat on the footing of shocking to the conscience also.
That's right, Malad. That's right. That's right. Para 42 now, Malad, straight away. And this is where 28.3 Malaj will come into.
23, yes.
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 Malaj. Para.
Page 81, yes.
Yes, Malaj. Internal page 81, on top 121, Malaj.
121.
Yes. Para 42. In the 96 Act, this principle is substituted by patent illegality. 42.1, a contravention of the substantive law of India would result in the death knell of an arbitral award. This must be understood in the sense that such illegality must go to the root of the matter and cannot be of a trivial nature. This again is really a contravention of 28.1a, where the place of the arbitration is so and so. In an arbitration other than international commercial arbitration, the arbitral tribunal shall decide the dispute submitted to the arbitration in accordance with substantive law for the time being in force in India. 42.3, Malaj may look at it straight away. Equally, the third subhead of patent illegality is really a contravention of section 28.3 of the Arbitration Act, which reads as under. Rules applicable to the substance of the disputes. In all cases, arbitral tribunal shall decide in accordance with the terms of the contract and shall take into consideration the usage of the trade applicable to the transaction. This last contravention must be understood with a caveat. An arbitral tribunal must decide in accordance with the terms of the contract, but if an arbitrator construes a term of a contract in a reasonable manner, it will not mean that the award can be set aside on this ground. Construction of a terms of a contract is primarily for an arbitrator to decide unless the arbitrator construes the contract in such a way that it could be said to be something that no fair-minded or reasonable person could do. In McDermott versus Burns standard, this honorable court held as under. It is tried that the terms of the contract can be express or implied. The contract of the parties would also be relevant factor. The conduct of the parties would also be a relevant factor in the matter of construction of a contract. The construction of the contract agreement is within the jurisdiction of the arbitrators, having regard to the wide nature, scope, and ambit of the arbitration agreement, and they cannot be said to have misdirected themselves in passing the award by taking into consideration the conduct of the parties. It is also tried that the correspondences exchanged by the parties are required to be taken into consideration for the purpose of construction of a contract. Interpretation of a contract is a matter for the arbitrator to determine, even if it gives rise to a determination of a question of law. Once thus it is held that the arbitrator had the jurisdiction, no further question shall be raised, and the court will not exercise its jurisdiction.
Basically, Mr. Chandra, it's if he wanders outside the domain of the contract,
right,
or that's a very risky proposition. I mean, the second test is very high,
yes,
because it's within his jurisdiction to interpret the contract,
correct,
but not befitting a reasonable person.
Correct.
Now,
I am on the second
gives
test.
much laxity to the code, actually, the 34 code.
No, I agree to that.
What may be reasonable to me may not be reasonable to you. Because I'm the judge, that will be held to be reasonable. And because the appellate court holds otherwise, it will go otherwise.
Correct. But Malaj would also
These are general tests, yes.
No, that's right. But
Malaj satisfy our conscience, basically, Mr. Chandra.
Absolutely. Number one. Number two.
The ultimate test.
Yes. Number two, my lords would also look at it from a perspective of what is known as an independent judicial mind or an independent third person
Absolutely.
test.
Absolutely. Absolutely.
Because otherwise, my lords may remember, the majority in our case held that the machine was never commissioned because it kept on breaking, according to them. After 80 days, after 120 days, after 3 months, and after a particular time, there was no commission. So they said that the moment it stops functioning, it is decommissioning, and then you have to then you have to again do commissioning,
You
which
say commissioning cannot be a continuous act. Commissioning happens
absolutely,
once only. It's a one-time
absolutely,
thing. And
absolutely,
otherwise it will open a floodgate. I mean, whenever it becomes defunct, then there'll be
absolutely.
decommissioning and all this.
So therefore, Malaj, that interpretation I'm
That's
saying,
absurd. You say an absurd interpretation.
that's right. That's right.
Very
That is the perversity that I'm striking at.
Got your point.
Everything else, Malaj, of course, they had the sort of they had the longest knee in the play in the joint kind of
Yes, yes.
jurisdiction, because
Yes.
we are in a 34 months.
I cannot go beyond the joint, basically.
Cannot go.
So that will
You
break
can't
the
break.
joint.
You can't break the joint. Absolutely.
Can't break the joint.
Absolutely.
Yes.
So this is only, that's why I'm reading 41 and 44. Although my lords are very, very, my lords,
Need
I'm
not
sorry to say,
read so much. I mean,
yeah, I'm sorry to
I'm
say,
already
my lords,
allergic to reading too many judgments, so please don't play on. And Sangyang also, please, this is a caveat to you. Be very specific, Mr. Achindra, because
yes,
Sangyang
yes,
has
my lords,
been
of course.
read so many times.
Yeah,
Although I'm
yeah,
not
my
sure
lords,
whether I've read the entire judgment ever, but
I know. And my lords, I'm conscious of the fact that my lords deal with these judgments day in and day out.
some of the paragraphs mostly.
Yeah.
Yes.
So my lords are aware, and perhaps my lords have sort of,
No, not that, but you definitely place your paragraphs, please.
Yes. My lords. So that's the only point, that I won't read the entire judgment as I did with
So
associate.
don't ever do it. I've never done it.
No, I will never do it, my lords. Why?
No,
Why
I've
would I
never read the entire judgment. That is what. So yes.
So 41, and just my lords may mark 44. There's another paragraph in that said
So,
judgment.
give
I
the
won't read
paragraphs,
it.
please. Give the paragraphs once
Yes,
again.
in Sangyong, my lords may have a look at para 60 or 10. Para 23 and 24, and one more para. Right? And write it just.
Yes.
Para 10. Para 10 just sets out what is the context, and 23 and 24 are relevant for us.
Good.
And sorry, Manoj, it's 10, 23, 24, and 70 onwards.
Good.
Yes, 70 to 76. I'm only going to read, my lords are aware of the law. I will just read the portion of the judgment.
Definitely.
That's all.
Thank you.
Yeah. My lords may just have a look at para 10 as to
Yes.
how the matter came up to be.
Yes.
2 out of the 3 members of the arbitral tribunal, by their award dated so-and-so, made at New Delhi, after noting the arguments of both sides, held that the circular could be applied as it was within the contractual stipulation, as has been held by the dispute adjudication board, and hence rejected the appellant's claim. While doing so, the majority award applied certain government guidelines of the Ministry of Commerce and Industry, as per which it was stated that the establishment of a linking factor to connect the old series with the new series is imperative and therefore required. The appellant's argument that the linking factor has divorced the contract and not at all required was therefore rejected. The majority award further made it clear that these guidelines are available on a certain website, as they were not on record. Para 13 of the guidelines was then referred to, and applying the arithmetic conversion method, which is one of the 3 methods referred to in the said paragraph, a linking factor was applied in accordance with the formula prescribed in the said method, which is as follows. So, this is a matter where something outside the contract was taken into consideration,
Right.
which was not within the influence of the parties and applied to the contract. That's in our case, the parallel that I'm drawing is that when they use the word continuous, continuous is nowhere, Manoj, in the warranty or in the scope of the warranty or in the scope of work in the contract. But in our case, the tribunal says the successful commissioning means that it must continually give a performance of the rated capacity for 24 months. That is what I'm saying, that therefore the word continuous is something which amounts to rewriting of the contract or adding the word to the contract. It's not it no more remains in the domain of interpretation of the contract. The
All right.
moment you add a word for a clause which is unambiguous, I could have understood that the clause is ambiguous and you were trying to interpret it by internal aids or external aids. But that is not the case. That is not what they say also, Malaj. Now,
Right.
Malaj, please straight away look at para 23 and 24 and then to para 7.
Yes.
Given this interpretation of law, I'm reading at 158, Manoj.
Yes, I've got it.
Yes. Given this interpretation of law, insofar as section 34 was concerned, this court in DDA versus so-and-so summarized the law as it stood at the point in time as follows. From the above, the following principle emerge. Award which is so-and-so, patent illegality. I'm just trying to highlight 23 and 24 on the point that it is patent illegality.
Yes, yes.
Then I won't read it, Manoj. I'll straight away get to para 70 at page 196.
Right.
It's again, Malaj, in 24, it talks about public policy.
Yes, yes.
And then associate builders, Malaj, is there. Malaj have already looked at it at 161.
Yes.
I don't want to read it all over again. Malaj have already noted it. 31 and 32 of the associate builders are really the crux.
Right.
Now, please getting to Malaj 196 at page para 70.
Yes, please. Yes.
Yes. Malaj will have a look at that. The expression most basic notions of justice finds mention in explanation 1. Here again, what is referred to is substantively or procedurally some fundamental principles of justice, which has been breached and which shocks the conscience of the court. That's the point, Manoj, that I'm trying to make. Thus, in Parsons, it was held that the convention allows the court in which enforcement of a foreign arbitral award is sought to refuse enforcement of the defendant's motion or sua sponte if enforcement of the award would be contrary to the public policy of the country. The legislative history of the provisions offers no certain guidelines to its construction. Its precursors in Geneva Convention and the 1958 Convention Ad Hoc Committee extended the public policy exception to respectively awards contrary to the principles of law and awards violative of fundamental principles of law. In one commentator's view, the convention's failure to include similar language signifies a narrowing of the defense. The United Nations Convention on the so-and-so, on the other hand, noted the authority in the field has seized upon this commission as indicative of so-and-so. Malaj, please see para 9 in itself. Skipping all of this, we conclude therefore that the convention
Most basic notions.
public policy defense. That's right, Malaj. Malaj may then need not read all these judgments. These are Malaj until page 73. These are all judgments.
Yes.
Which Malaj are very well aware of. Coming to state away 73, I want to show what is the how the court deals with the fact in issue.
Right.
Given these parameters of challenge, let us now examine the arguments of the learned counsel on behalf of the appellant. There can be no doubt that the government guidelines that were referred to and strongly relied upon by the majority award to arrive at the linking factor were never in evidence before the tribunal. In fact, the tribunal relies upon the said guidelines by itself and states that they are found to be on a certain website. The ground that is expressly taken in section 34 is the following. It is pertinent to mention here that no such guidelines of the ministry or industrial development had been filed on record by either of the parties, and therefore the tribunal had no jurisdiction to rely upon the same while deciding the issue before it. Accordingly, the impugned order is liable to be set aside. The learned counsel for the respondent also agreed that these guidelines were never in fact disclosed in the arbitration proceeding. This being the case, and given the authorities cited here and above, it is clear that the appellant would be directly affected, as it would otherwise be unable to present its case, not being allowed to comment on the applicability or interpretation of those guidelines. For example, the appellant could have argued, without prejudice to the argument that linking is divorce the contract, that the 3 methods for linking the new series with the old series, either the second or the third method would be preferable to the first method, which the majority award has applied on its own. From this reason, the majority award needs to be set aside under so-and-so. Para 76, Malaj, straight away. When it comes to public policy of India, arguments based upon the most basic notions of justice, it is clear that this ground can be attracted only in exceptional circumstances, when the conscience of the court is shocked by the infraction of the fundamental notions of the principles of justice. It can be seen that the formula that was applied by the agreement continued to be applied till February 2013. In short, it is not correct to say that the formula under the agreement could not be applied in view of the ministry's change in the base indices from the year so-and-so. Further, in order to apply a linking factor, a circular unilaterally issued by one party cannot possibly bind the other party to the agreement without that the other party's consent. Indeed, the circular itself expressly stipulates that it cannot apply unless the contractors furnish an undertaking, an affidavit that the price of judgment and the circular so-and-so is acceptable. We have seen how the appellants gave such undertaking only conditionally and without prejudice to its argument that the circular does not and cannot apply. This being the case, it is clear that the majority award has created a new contract for the parties. By applying the said unilateral circular and by substituting a workable formula under the agreement by another formula, dehors the agreement. This being the case, the fundamental policy principles of justice has been breached, namely that a unilateral addition or alteration of a contract can never be foisted upon an unwilling party, nor can a party to the agreement be liable to perform a bargain not entered into with the other party. Clearly, such a course of conduct would be contrary to fundamental principles of justice as followed in this country and shocks the conscience of this court. However, we repeat that this ground is available only in exceptional circumstances, such as that fact situation in the present case. Under no circumstances can any court interfere with an arbitral award on the ground that justice has not been done in the opinion of the court. That would be an entry into the merits of the dispute, which, as we have seen, is contrary to the ethos of Section 34, as has been noted in the earlier judgments. So therefore, argument, Malaj, here is that even in our case, Malaj, something which was not in the contemplation of the party in a continuous operation is something that has been read into it, which was never the part of the contract. Now, Malaj, please refer to the next judgment, Sal Udyog. Oh, sorry, PSA Sikal, Malaj. And the relevant paras there are 40, 41, 44, 45, 60, 80, 81, 85, and 89. 85 to 89. This is on the point of leaving out relevant evidence, Malaj, and rewriting of the contract. Because one of my arguments also in the second part, in the second leg of the hearing was that our positive evidence, which has come on record, has not been taken into consideration at all. It has not been discussed. It has not been dealt with. It has not been cited. It has not been stated that these are not relevant and so on and so forth. It has not been described at all. It has not been touched upon. Now, Manoj, please see para 40 straight away to begin with.
Yes.
It is at page
210.
Yes. (212), yes.
210 probably. Para 40. Para 42 or 40?
Just a minute. I wanted to start with 40.
You said
Yes, it's
40,
210.
41, 44.
Yes, Manoj, 210.
Yes.
I'm sorry, Manoj. Why on 212 also there is 40?
12 also there is another 40.
Oh, it's an internal page in
No,
Sangyong.
internal. That's internal.
Yes,
Without,
that's-
not
yes,
in bold.
Yes. That's internal page of Sangyong. I'm sorry.
The bold numberings are only there.
Yes, Manoj. Yes.
So are you relying on the
Yes. In fact, I wanted to start there, Manoj.
40, the bold one or page
No,
2?
I will.
Just check up, please.
Yes. Manoj, please come to 210. 41, Manoj, see.
Yes.
It is para quoted from MMTC.
Right.
It says, as far as 34 is concerned, the position is well settled by now that the court does not sit in an appeal. My lords may then come to straight away para 13 on page 211.
Right. Yes.
It is relevant to note that 2015 amendment, the above position stands somewhat modified pursuant to the insertion of the explanation 1 to 34.2. The scope of contravention of the Indian public policy has been modified to the extent that it now means fraud or corruption in the making of the award, violation of section 75 or 81 of the Act, contravention of fundamental policy of Indian law, and the conflict with the most basic notions of justice and morality. Additionally, subsection 2A has been inserted in section 34, which provides that in case of domestic arbitration, violation of Indian public policy also includes patent illegality appearing on the face of the award. The proviso to the same states that an award shall not be set aside merely on the ground of an erroneous application of law or by reappreciation of evidence. As far as interference with an order made under 34, this is not relevant, Manoj. We are not.
You can come to para 44, Mr. Chinta.
Yes, yes, Manoj.
Not public policy, but patent illegality. Perversity.
Yes. Associate builders, Manoj, have already seen at 41.
Yes, and that is discussed again in 45 also.
Yes, absolutely. And 44, a decision which is perverse, though would not be a ground for challenge under the public policy of India, would certainly amount to a patent illegality appearing on the face of the award. However, a finding based on no evidence at all, or an award which ignores vital evidence in arriving at its decision, would be perverse and liable to be set aside on the ground of patent illegality. To understand the test of perversity, it would also be appropriate to refer to, this is again Manoj, para 31
Please
and
don't,
32.
yes.
Yes, I'm not going to read it. Now, Manoj, may please straight away come to para 60. These are the questions before the court. Para 68, 218, 218.
Yes, thank you.
The questions, therefore, that we will have to answer are as to whether the arbitral tribunal was justified in finding a change in law which entitled the licensee to invoke 14.3 of the agreement, as to whether the arbitral tribunal was justified in converting the contract from royalty payment module to revenue sharing module of berth number so-and-so with the claimant's liability to revenue share being fixed at so-and-so. These are factual points, but it just shows the application of law here. That's all.
Yes, exactly.
61. For answering the aforesaid question, we will have to consider the documents placed on record. Apart from that, we will also have to take into consideration the conduct of the parties and their intention. Now, Malaj, may please come straight away to para 67. It says, page 219.
Yes.
It could thus clearly be seen that even in the 98 guideline, do not mention that the royalty could be factored in the cost while determining the tariff. Though the said guidelines observe that the port pricing may continue to be cost-based with an assured rate of return, it further observed that such a concept of an assured rate of return is not in consonance with the competitive system. Thus, it is amply clear that when the bids were invited and SECL submitted its bid and LOI was issued to it, there was no policy at all. Even the 98 guidelines do not provide for factoring the royalty in cost while determining the tariff. No doubt, when the first proposal for the revision of tariffs was submitted by the SECL, in its comments submitted to TAMP, TPT has supported the proposal submitted by SECL. It is also undisputed that TAMP by order dated so-and-so has approved the proposal with regard to fixation of tariff.
You can come to para 80, Mr. Chandra, if you
Yes,
please.
Malab.
Because unless that it will be repeated there also.
Yes.
In a nutshell.
A conjoint reading of all these documents would reveal that when the bid document was published in 1997, SECL tendered its bid in October 97 and submitted its financial offer in December 97. And the LOI was issued to SECL on January 1998. There were no guidelines at all. Even the guidelines of February 98 do not provide for royalty being factored as cost while fixation of tariff. On the contrary, the tariff order of 1999 specifically clarifies that it has left the royalty issue to be decided by the TPT and the Government of India. It has specifically clarified that the approval by TAM should not be interpreted to be amounting to any implicit approval of royalty-related issue. Further, the tariff order issued on 20th September 2002 specifically rejects the claim of SECL for factoring any royalty as the cost while tariff price fixation. As already stated herein, SECL has challenged the said order before the Madras High Court by way of the writ petition, which petition has been allowed. It is also not in dispute, para 81. In this scenario, the finding of the tribunal that there was a law when the agreement was entered into between the parties, which provided royalty as a pass-through, and that the said law has been changed for the first time in 2003 and subsequently again in 2005, in our view, is a finding based on no evidence. Had the arbitral tribunal perused the tariff orders, it would have found that in the 1999 tariff order, TAMP had specifically observed that its approval of the tariff should not be construed as its implicit approval of royalty-related issue, and the 2002 tariff order specifically states that royalty was not permitted to be factored in the cost while determining tariff. The arbitral tribunal has totally failed to take into consideration this aspect of the matter. As such, we are of the view that since the finding of the tribunal that there was an existing law to the effect that the royalty payable shall be permitted as pass-through in the cost while fixation of tariff is based on no evidence, and finding that there was a change in law into the 2003 and 5 is based on without taking into consideration the relevant evidence, would come in the realm of perversity as explained by this court in para 31 of the Associate Builders, The findings are based on no evidence and ignorance of vital evidence in arriving at its decision. Yes.
Mr. Shinde, we'll start from para 85. I'll come
Yes.
back in 10 minutes and then
No,
start.
no, Manoj. Yes.
Thank
No
you.
difficulty.
Thank you.
Oh. My lord.
Yes, please.
Yes. At para 85, my lord, straight.
Yes.
Page 224.
Right.
However, ignoring the stand of the TPT by impugned award, the arbitral tribunal has thrust upon a new term in the agreement between the parties against the wishes of the TPT. The royalty payment method has been totally substituted by arbitral tribunal with the revenue sharing method. It is thus clear that the award has created a new contract for the parties by unilateral intention of the seeker as against the intention of TPT. After referring to various international treatises on arbitration and judgments of the other jurisdiction, this court in Sangyong observed thus. However, when it comes to public policy of Indian law, of policy of India, argument based upon most basic notions of justice, it is clear that this ground can be attracted only in exceptional circumstances when the conscience of the court is shocked by infraction of fundamental notions of principles of justice. It can be seen that the formula that was applied by the agreement continued to be applied till February. I have already read this portion, Malaj.
Yes, yes, yes.
In Sangyong, I'm not going to read it again. 87 Malaj may have a look. As such, held by the court in Sangyong, the fundamental principle of justice has been breached, namely that a unilateral addition or alteration of a contract has been foisted upon an unwilling party. This court has further held that a party to the agreement cannot be made liable to perform something for which it has not entered into a contract. In our view, rewriting of a contract for the parties would be breach of fundamental principles of justice, entitling a court to interfere, since such case would be one which shocks the conscience of the court and as such would fall in exceptional category. We may gainfully refer to the observations of this court in Bharat Coking Coal. There lies a clear distinction between an error within the jurisdiction and error in excess of jurisdiction. Thus, the role of the arbitrator is to arbitrate within the terms of the contract. He has no power apart from what the parties have given him under the contract. If he has traveled beyond the contract, he would be acting without jurisdiction. Whereas if he has remained inside the parameters of the contract, his award cannot be questioned on the ground that it contains an error apparent on the face of the record. It has been held that the role of the arbitrator is to arbitrate within the terms of the contract, and he has no power apart from what the parties have given him under the contract. If he has traveled beyond the contract, he would be acting without jurisdiction.
Yes.
And ultimately, Malaj, they set it aside on that. Now, Malaj, may please refer to Sal Udyog, the next judgment at page 288. The relevant paras are from 14 to 16 and 23 and 26. This is where, Malaj, the term of the contract, you cannot be contrary to the term of the contract and can't ignore a portion of the contract. Malaj, please have a look at 14 to 16, which is the principle of law. I will not repeat it. Malaj have already read it.
Yes, yes.
Just mark it, Malaj. 14 is Associate Builders, 15 is Sangyong.
Right.
And 16 is Delhi Metro. Delhi Metro, I will refer to later. Malaj may just mark it. Now, Malaj may please refer to straight away there on the facts of the issue.
Yes.
In fact, Malaj may just come to page 237, para 16. I will only read from Placitum C.
Yes, please.
The permissible grounds, and this is one of the portions in Delhi Metro Rail, Delhi Airport Metro. The permissible grounds for interference with the domestic award under 34(2)(a) on the ground of patent illegality is when the arbitrator takes a view which is not even a possible one, or interprets a clause in the contract in such a manner which no fair-minded or reasonable person would, or if the arbitrator commits an error of jurisdiction by venturing outside the contract and dealing with matters not allotted to him. An arbitral award stating no reasons for its finding would make itself susceptible to challenge on this account. The conclusion of the arbitrator, which are based on no evidence or have been arrived at by ignoring vital evidence, are perverse and can be set aside on the ground of patent illegality. Also, consideration of documents which are not supplied to the other party is a facet of perversity falling within the express patent illegality. Malaj, may now please turn to straight away page 20, para 23, page 240.
Yes.
On a conspectus of facts of the case, it remains undisputed that though the appellant state did not raise an objection before the arbitral tribunal on the claim of the respondent company seeking deduction of supervision charges, for which it relied on in clause 6B of the agreement and the circular dated so and so to assert that the recovery of supervision charges along with expenses was a part and parcel of the contract executed with the respondent company. The said objection was turned down by the learned sole arbitrator by giving a complete go-by to the terms and conditions of the agreement, governing the parties and observing that there is no basis to admit any such indirect expenses. The circular dated 27/7/1987, issued by the government of Madhya Pradesh, provides for imposition of 10% of the supervision charges on the amounts calculated towards the cost of sal seeds. In the expenditure incurred was also ignored. Pertinently, the respondent company has not denied the fact that the supervision charges were being levied by the applicant state and being paid by it without any demur as a part of the advance payment made on an annual basis right from the date the parties had entered into the first agreement, that is 30th of August 1979. This fact is also borne out from the specimen copies of the orders filed by the appellant state with the appeal that amply demonstrate that the cost of the sal seeds required to be paid by the respondent company included supervision charges described as Paryavaran Paryavarikshan Vyay in vernacular language. It was only after the appellant state had terminated the second contract that the respondent company raised a dispute and for the first time claimed refund of the excess amount purportedly paid by it to the appellant state towards supervision charges incurred for supply of sal seeds. In our opinion, this is patent illegality that is manifest on the face of the arbitral award, inasmuch as express terms and conditions of the agreement governing the parties, as also the circular dated so and so, issued by the government of Madhya Pradesh, have been completely ignored. We are afraid that the plea of waiver taken again by the appellant state on the ground that it did not raise such an objection in the ground spelled out in Section 34 petition and is therefore estopped from taking the same is in the appeal preferred under Section 37 or before this court would also not be available to the respondent company, having regard to the language used in 34(2) of the 1996 Act that empowers the court to set aside an award if it finds that the same is vitiated by patent illegality appearing on the face of the same. Once the appellant state had taken such a ground in Section 37 petition and it was duly noted in the impugned judgment, the High Court sought to have interfered by resorting to 34(2)(a), a provision which would be equally available for application to an appealable order under 37 as it is a petition filed under Section 34. In other words, the respondent company cannot be heard to state that the grounds available for setting aside an award under subsection 2A of the Section 34 of the 1996 Act could not have been invoked by the court on its own in exercise of jurisdiction vested in Section 37. Notably, the expression used in subsection is that the court finds that. Therefore, it does not stand to reason that the provision that enables the court acting on its own in deciding a petition under 34 for setting aside an award would not be available in an appeal under 37. Reliance placed on so and so is also now. Please come to para 26 straight away. To sum up, the existence of clause 6B in the agreement governing the parties has not been disputed, nor has the application of the circular dated so and so by the government of Madhya Pradesh regarding imposition of 10% supervision charges and adding the same to the cost of the sal seeds. After deducting the actual expenditure being questioned in the respondent company, we are therefore of the view that failure on the part of the learned sole arbitrator to decide in accordance with the terms of the contract governing the parties would certainly attract the patent illegality ground. As the said oversight amounts to gross contravention of Section 28(3) of the 1996 Act that enjoins the arbitral tribunal to take into account the terms of the contract while making an award. The said patent illegality is not only apparent on the face of the award, it goes to the very root of the matter and deserves interference. Accordingly, the present appeal is partly allowed, and the impugned order, insofar as it has permitted deduction of supervision charges recovered from the respondent company by the appellant state as a part of the expenditure incurred by it while calculating the price of the sal seeds, is quashed and set aside, being in direct conflict with the terms of the contract governing the parties and the relevant circular. The impugned judgment dated so and so is modified to the aforesaid extent. So similarly, Malaj, in our case, where an amount has been given contrary to clause 14 regarding the warranty, where it says that it will only be valid for 24 months from the date of the supply, that aspect not being taken into consideration and completely ignored is nothing but contrary to the award, is contrary to the terms of the contract. That is where, Malaj, I would want the application of the law.
Yes.
To be. Then, Malaj, may please refer to. This applies, Manoj, in both the argument of the argument of clause 14 in our matter and also for non-consideration of the same. Then, Manoj, may come to straight away the next judgment. This is a Supreme Court, IRCTC versus Brindavan Foods. The relevant paras are 62 to 73. I am at page 269.
Yes, thank you.
In fact, Malad may come to straight away 270, because prior to that, it's all the law which Malad has already looked at.
Right, right.
Page 270, para 68, Malad.
68, yes. Thank you.
Given the settled legal position emerging from the above referred decisions, it is manifest that the arbitrator erred in assuming that he was only interpreting the terms and conditions of the contracts, and was therefore at liberty to place a contrary construction on the express language used therein, which was actually reflective of the policy decision of the railway board. So similarly, Malaj, I'm saying that they have put a contrary construction to what is stated specifically in clause 14, clause 14 of the guarantee agreement.
Yes.
Which was actually reflective of the policy decision of the Railway Board, Ministry of Railways, Government of India in its circular referred to in so and so, merely because there was a subsequent change in the policy with prospective effect based on the recommendation made by the IRCTC itself, whereby parity was brought about in the tariffs to be paid by the caterers to the first and the second regular meals. It did not have the effect of wiping out the policy decision set out in the commercial circulars dated so and so. In its wisdom, having chosen to challenge the aforestated circulars, BFP did not carry it forward after the dismissal of its writ petition, and in consequence, BFP and the other caterers can raise no objection at this stage to the policy decisions embodied in those circulars, which were merely replicated and applied in their contracts. Once the contracts between the parties were strictly in terms of and in keeping with the extant policy, the terms of such contract could not have been interfered by the arbitrator, contrary to and in violation of the policy which remained intact after the dismissal of the BFP's writ petition. The arbitrator was therefore not justified in undertaking interpretation of the contractual terms contrary to language used therein, which merely mirrored the policy decision of the Railway Board, which were binding in nature. In effect, the arbitrator practically rewrote the contract between the parties in such a manner that it was in contradiction with the policy decision set out in the circulars dated so and so, which he could not have touched. In the light of the judgment referred to supra, this error on the part of the arbitrator resulted in award not only being against the public policy of India, but also made it patently illegal. Section 28(3) mandatorily required the arbitrator, while deciding and making the award, to take into account the terms of the contract and the trade usage applicable to the transaction. The trade usage in this regard were the policy decisions of the Railway Board, Ministry of Railways, Government of India, that governed contract and its nature. Therefore, the arbitrator was bound to consider such policy decisions in that light and evaluate the contractual terms in context thereof. In the present case, arbitrator completely overlooked the weightage to be given to the policy decisions embodied in the Railway Board circulars and compounded the error by contrarily interpreting the contractual terms, which were strictly in consonance therewith to grant relief to the case. They eventually set it aside at page 73. At para 73, page 273. I'm not going to read it, Manoj.
No.
Now I'm shifting, Manoj, to the judgments of this honorable court at page 274.
Yes.
In as much as, Manoj, these have been authored by the honorable court.
Yes. Give me the
Manoj will of
paragraphs.
course remember it, but I will just very quickly refer to some paragraphs.
No, I actually don't. Once the judgment is over, you need to. Yes. Unless it's cited. Yes.
Yeah, it is, Manoj. It is cited.
What are the paragraphs?
Yes, Manoj. Paras in this is 157, 30, 38, 39, 40, 42, and 43. This is on the point, Manoj.
Please repeat after 13. Please repeat
Sorry,
after
Manoj.
157, then
30, 30,
yes,
38,
yes.
39, 40, 42, and 43.
Very good. Thank you.
This is on the point, Manoj, that the court cannot interpret contract contrary to its terms and cannot rewrite. And in fact, this was a case, Manoj, where the clause was very, very clear. And the honorable court goes on to say that where there is no ambiguity, you can't get into interpretation. Please have a look at that, Manoj, first. At paragraph 1, Manoj may see. The issue was in relation to reimbursement of service tax.
Yes.
To the respondent to the tune of rupees 49 lakhs. Short background is, Manoj, this is respondent participated in the tender by the petitioner Railway for escorting job of coach attendant for bedroll distribution of various trains at Santragaji. At Santragaji Coaching Depot. Now, Maharaj, may please see para 5. Over the page, learned counsel for the petitioner railway argues that in terms of clause 2.2 of the contract, the rates quoted by the tenderer shall include all incidental charges inter alia, VAT, sales, excise, duty, octroi, and other tax and duties, etc. As per the tax authorities, the nature of service provided by the respondent became liable to service tax in July 2012. However, by subsequent notification dated 27th of May 14, service tax was made inapplicable for the work done for railways. Such exemption was again withdrawn by a notification dated 1/3/2015. The said notification was implemented by a further notification of 26th of May 2015. Thus, as on the date of opening of the bids in the tender in question, service tax had been reimposed in respect to the works done for the railways. It is contended that the arbitral tribunal deviated from the contract between the parties, particularly clause 2.2 thereof, by directing service tax plus interest to be borne by the petitioner, railway, although the rates quoted by the bidders as per 2.2 were to include all incidental charges, including taxes and duties. Thus, the award violated Section 28(3) of the 1996 Act and is accordingly vitiated by patent illegality. Malaj, may please refer straight away to para 30.
Right.
At page 278.
Yes, got it.
I'm not referring to the law in between, my lords already know it. Yes, 278, para 30. Clause 2.2 does not restrict itself only to the taxes and duties mentioned therein, such as VAT, sales tax, excise duty, and octroi, but also supplements the same with the expression and other taxes and duties, etc., thus covering all other taxes and duties, even apart from those specifically mentioned in the said clause. Since on the date of the contract between the parties, service tax was already payable for railway works, the expression and other taxes and duties, etc., included service tax. Clause 2.2 of the contract is unambiguous on such score. Hence, no external aid of any other document is required for interpreting the said clause. An internal estimate of the petitioner railway was relied on by the arbitral tribunal for interpreting clause 2.2 of the contract. However, such an approach was patently perverse for 3 reasons. Firstly, Malaj may now come straight away to actually
38.
38, yes.
Yes.
Taking resort to such external aid where there was no ambiguity whatsoever in clause 2.2 is in itself a patent illegality which vitiates the impugned award. It is an entrenched principle of Indian law that the courts cannot rewrite a contract between the parties. The said concept is an integral part of the fundamental policy of Indian law, violating the same tantamounts to contravention with the fundamental policy of Indian law and being in conflict with the most basic notions of justice. Hence, such contravention affords a ground under section 34(2)(b)(2), including the explanations. Section 28(3) of the 1996 Act provides that while deciding and making an award, the arbitral tribunal shall in all cases take into account the terms of the contract and trade usages applicable to the transaction. Since the terms of the contract between the parties in the present case were unambiguous, contravention of the same by the arbitral tribunal tantamounts to a patent illegality within the contemplation of section 34(2)(a) of the 1996 Act as reiterated in the state of Chhattisgarh's case. Then Manoj may please straight away turn to 40. Sorry, 40 we already read, 42.
42.
Learned counsel for the respondent places reliance on associate builders and NHI to argue that the arbitral tribunal could very well have considered material on record and correspondence between the parties to interpret the clauses of the contract. However, a judgment carries a ratio in the context of its facts and cannot be blindly applied to all and sundry cases. It is equally well settled that when the terms of the contract are unambiguous, no external aid needs to be resorted to for purpose of interpretation of the same. In the present case, the expression and other taxes and duties in clause 2.2, without any iota of ambiguity and doubt, mandates that the rate quoted by the tenderer has to include all taxes and duties and the like applicable to the works under the contract. Therefore, there is no scope of taking aid and for any further document to interpret the same. Also, the estimates which was relied on by the arbitral tribunal to interpret the clause is neither a part of the contract nor an agreement between the parties, but as discussed above, is an internal document of the petitioner railway for arriving at the estimated price of work. Furthermore, the estimate deals only with the wages of the workman in terms of, Malaj, this is specific to
This
the
is
law.
specific to the case. Right.
Yes.
Right.
And then Malaj may please see, that's it. So
That's
the point being that where the clause is very, very clear, there is no need of any internal or external aid. Then Manoj may please turn to the next judgment of Oriental Insurance versus Sarada Rani. This is also, Manoj, on the point of no evidence or without any evidence. I'm sorry.
Yes.
Unilateral, yes. Manoj, may please see now paras. Paras 23, 29, and 32.
Right.
The facts are there Manoj, at para 6. Sorry, the facts are there at para 1. The matter arises out of the claim made by the respondent for insurance in view of the loss suffered due to the damage of cement bags stored for the purpose of its business by the respondent due to waterlogging. An award of 60 lakh rupees was passed solely on the basis of Exhibit T issued by the claimant respondent to the present insurance petitioner insurance company. Unilateral claim of the respondent does not comprise of proof, and the award is perverse. This I am using, Manoj, for the reason that in our case, there is only in cases of diesel and the
Yes, yes. Their
electricity, it is only their document,
Right.
and there is no substantiating at all.
Hmm.
One is just a ledger, the other one are just DMRs, are just Damodar Valley Corporation bills, and nothing beyond that, Manoj. In fact, to my mind, that does not even fall within the definition of damages under 73 and 74. That cannot be the basis of damages or the loss that you suffered, so to say. Now, Manoj, may please have a look at para 23. There is no justifiable at page 285.
Yes.
There is no justifiable basis why the tribunal chose the letter dated January 7 as the sole basis for granting the claim. The letter itself is vague inasmuch as it mentions the entitlement of claimant to be in excess of 60,000, not specifically quantifying the exact amount of damages. Moreover, the number of damaged bags as indicated therein and the consequential quantity of cement do not tally at all with the exorbitant claims of 2,988, I presume Malaj, it's metric tons, which was originally claimed by the claimant to have been damaged. That apart, the claimant has made various claims at various points in time. For example, it claimed 1,13,000 on so and so, and again on 1,03,000, whereas the original claim was much higher. In view of such inherent contradiction in the claims of the claimant, no reliance can be placed at all in the unilateral claim as embodied in the letter dated so and so. Moreover, it defies all principles of jurisprudence as to how the unilateral claim of the claimant, which does not even qualify as pleading supported by due verification affidavit, could be equated with proof of such claim. The claim was even contradicted by the claimant itself in various other places, including a subsequent letter. Thus, in the absence of any proof whatsoever, in spite of liability being admitted in principle by the insurer, the arbitral tribunal acted in a palpably perverse fashion in granting the claim of rupees 60,000 without any material basis. The letter of the claimant, even though contemporaneous with the loss, could not be elevated to the plane of proof of such claim. The reliance on so and so by the tribunal was also misplaced. The learned single judge in the said judgment, while referring to Halsbury's laws of England, was merely contemplating a situation where the damages could not be assessed with any mathematical accuracy. As opposed thereto, in the present case, the assessment did not lack accuracy, but was entirely baseless, without any foundational evidence at all. Moreover, in the said judgment, what was being considered was claims which are by their very nature incapable of being assessed with accuracy, such as in respect of pain and suffering, loss of exception of life, and loss of a chance of winning a prize. Such circumstances are completely different from the present case. In the instant case, the claim made by the claimant was a fully quantifiable amount. The claimant had to prove the exact number of damaged cement goods, the amount of the cement in each of the bags, and the price of such bags. In view of the petitioner having failed to prove the most important components out of those, being the number of the damaged bags, there was no occasion for the arbitral tribunal to grant any amount to the claimant whatsoever. Thus, this is not a situation where an exact figure cannot be arrived at, and the tribunal is compelled to resort to reasonable guesswork, but a case where the tribunal, relying on no material basis whatsoever, arbitrarily granted an amount to the claimant. The very absence of any basis vitiates the award by patent perversity.
Right.
30, Manoj may look at 32. It is set aside, Manoj, in these.
Yes.
Then Manoj may look at the next judgment of Union of India versus Jai Bharat Construction.
Yeah.
And in this matter, Manoj, at para 27.
All right.
292. Relevant paras are 27, Manoj, 232, then 37, 38, and 41.
All right.
Manoj, may I please have a look at 27 at page 292. The tribunal proceeded on a perverse basis, committing a patent illegality by acting contrary to the contract as mandated under section 28(3), as well as by overlooking the relevant evidence while relying on the irrelevant document in passing the aforesaid two components of the impugned award. Since the comity and consensus between the parties are the very source of authority of the arbitrator, the tribunal was bound by the terms of the contract between the parties, having thus acted contrary to the specific terms of the agreement, including the GCC, on both the counts by directing refund to the security deposit and not granting the total claim of risk of cost. The learned tribunal acted with patent illegality. While holding so, the court is aware that patent illegality by itself would not justify interference, since the award impugned herein was passed long before the introduction of 2A. Thus, the said subsection is not applicable to the instant challenge. The crucial question which arises thus is whether any such illegality or even perversity is sufficient to be termed as shocking to the conscience of the court or in conflict with the public policy of India. It has been Section 34 2B2 of the 96 Act provides that an arbitral award may be set aside if it is in conflict with public policy of India. The other grounds of challenge under 34 are not applicable to the present case in view of the conclusions above. It has to be kept in mind that explanation 1 of 34 2B of the 1996 Act was also not introduced at the time when the impugned award was passed. The said explanation clarifies the scope of the award being in conflict with the public policy of India and restricts the same primarily to fraud, corruption, conflict with most basic notions of morality or justice, and contravention with fundamental policy of Indian law. Since such yardsticks had not been introduced when the present impugned award was passed, the test of in conflict with the public policy of India has to be just that, not confined to the tests of explanation 1. Then Manoj, may please see 37.
Yes.
Hence, primacy of terms of the contract is also a cardinal part of the policy of India, as also embodied in section 28(3) of the 1996 Act. Pitted against each other, the policies of primacy of contract and the least judicial intervention have to play out in respect of each other in the factual context and circumstances of each case. 41. Seen from such perspective, in conflict with public policy of India shall also mean in contravention with the fundamental policy of Indian law and in conflict with most basic notions of morality or justice. Coming back to the present impugned award, on the security deposit issue, as well as the risk cost issue in the present case, the tribunal relied on the self-same logic that the claimant was liable only for the portion of the work for which drawings were provided to the claimant. However, the said consideration has no connection with either of the said issues. On the claim of refund of security deposit, it is noteworthy that the tribunal did not frame any issue as to the unlawfulness of the termination, nor did it arrive at any finding that the termination by the railway was unlawful or dehorsed the provisions of the GCC. The tribunal also did not set aside the termination. The parties were not granted any opportunity to address the issue of lawfulness or otherwise of the termination by the railway. If the termination was valid, the tribunal had no occasion to grant the claim of refund on the finding that the refund of this amount is a genuine agreement claim on termination of the contract wrongfully by the respondent as being wrongdoer and defaulter. Such conclusion is thus in conflict with the most basic notions of morality and justice. The division between the portion of the work for which drawings were supplied and for which drawings were not is artificial and perverse, since the unrebutted annexure B provided by the railway clearly enumerated the incomplete work which could be done by the claimant even without drawings being furnished. Such evidence was completely overlooked by the tribunal, and it proceeded on the premise that the termination was wrongful without otherwise having held so or declaring the termination bad. Again, on the issue of risk and cost liability of the claimant, the tribunal took into consideration an entirely irrelevant document, Annexure C, which merely specified the portion of the work for which drawings were provided by the railway. However, overlooking Annexure B, which furnished the work which could be completed even without drawing being supplied. It does not require reappreciation of the evidence to see that Annexure A and B, which were the only germane document in the context of risk and cost, were completely overlooked by the tribunal, whereas Annexure C, which had nothing to do with the issue, was solely relied on. Annexure A disclosed the amount payable, and Annexure B is its subset, showing the work which was left unfinished by the claimant but could not be done without revised drawings. Again, the underlying concept of risk and cost was given a go-by, which is that the employer is to be compensated for the work left incomplete by the respondent contractor, which had to be completed through a third party. An essential component of the fundamental policy of Indian law is that the tribunal court must advert to relevant document and the material evidence to come to its conclusion and not rely on extraneous and irrelevant material to decide an issue. Such basic tenet of the fundamental policy of Indian law having been violated, the award is tainted by perversity and deserve to be set aside.
Yes.
Similarly, Manoj, in our case, we are saying that the relevant evidence that we had put has been completely overlooked, and merely documents which are per se not proof per se have been relied on, and amounts up to 7 crores have been awarded only on the basis of the bill of the DVC and on the basis of their internal own ledgers. That is where, Malaj, where we are putting the thrust on. Now, Malaj, may please see the next judgment. Minitech Global versus Keshoram Industries. The relevant paras, Malaj, in these is 54 to 59, 61, 66, and 74. This is a copy of the court. It's
Yes.
not a quoted judgment, but a copy of the court order. Para 54, let's have a look at page 311.
Yes.
I'm not referring to the law Malaj cited because that's
Need not,
duplication.
need not.
Yes.
Yes.
I'm just straight away going to where application
Yes.
is there.
Right.
311. The next question which follows necessarily is whether future commitment charges could be granted beyond 6 months notice period. Such aspect has been discussed elaborately by Supreme Court in Amritsar Gas. As per the said judgment, if an agreement is otherwise revocable, in the event of an invalid termination, the compensation can be granted only for the period of notice. Such logic is self-evident in the context of the incident list, since it was always open for both the parties to exit from the contract at will by issuing a termination letter at any point of time during the pendency of the contract. No separate reasons were to be assigned for doing so, making the contract determinable at will. The only rider was to issue a 6 months prior notice, which has not been done by the respondent in the present case. The AT could not look beyond the said mandatorily notice period to assess any entitlement of the claimant beyond the said period, since in any event, it was always open for the respondent to exit the contract at will. Even if prior notice was given, the agreement would come to an end within 6 months from the same. In the present case, such 6 months commenced from March 7, 17, which was the date construed to be the date of stoppage of production, never to be resumed again. In fact, the parties by their subsequent conduct made it evident that both of them proceeded on the premise that the March 7, 17 communication tantamounted to the expression of interest by the respondent to exit the contract in terms of clause 1.11. Even if notice was given on the date of termination after the lapse of 6 months, the claimant could not have any further entitlement on the strength of the contract, since all contractual rights would have come to a dead end then. Hence, the AT committed patent illegality in acting contrary to the proposition laid down in Amritsar Gas to grant future commitment charges much beyond the said 6 months period. 61. The Supreme Court has repeatedly held, as reflected in Sangyon as well, that the AT cannot deviate from the terms of the contract. In fact, such proposition is premised on 28(3) of the 96 Act, which provides that while the deciding and making the award, the arbitral tribunal shall in all cases take into account the terms of the contract and trade usages applicable to the transaction. Malaj, may now please look at 66. This is, Malaj, on a point that I raised, that the fact that we had provided a bank guarantee during the period of the guarantee, and that bank guarantee was never encashed. Therefore, I had raised an argument of doctrine of estoppel. That is something, Manoj, that finds resonance in 66, in para 66. Insofar as the commitment charges.
Yes.
Insofar as the commitment charges, I'm reading at page 314.
Yes, I've got
para
it.
66, Manoj.
Got it.
Insofar as the commitment charges already paid by the respondent are concerned, the tribunal did not direct refund of the same. Such decision on the part of the AT was justified. The respondent based its claim on the refund of an alleged mistaken belief and fraudulent inducement, none of which was specifically pleaded or proved by the respondent. That apart, the respondent, with its eyes open, participated in the business transaction and paid commitment charges during the notice period upon bills being raised by the claimant much after the termination, and is thus estopped from challenging the same, having not raised any demur at the relevant point in time. So in our case, Malaj, two aspects factually are relevant. During the period of during the period when the machine was there with them, they got the machine serviced and paid us that amount. Whereas we were whereas we were under an obligation to service it for free if it was a manufacturing defect per se. But they paid the amounts without any demur. Secondly, not only paid the amounts, never encashed the bank guarantee during that time. In fact, never encashed the bank guarantee at all until termination. Until repudiating my product.
Yes.
So estoppel by conduct is what I am highlighting, Malaj.
Right.
That has been taken note of and applied. Then Malaj, may please have a look at page para 74. This is 74. I am on the point of mitigation of losses.
Yes.
That in our case, we are saying that one of the arguments that we also
That
raised.
electricity.
Yes, Malaj. Yes. Electricity. Right. We also raised that if DVC was more convenient to you,
Yes.
then there was no reason for you to use the generator sets. If that was proving to be more expensive, then you already had a source of DVC per se. Of course, we are saying without dehorse to the fact that your quantification even for DVC is incorrect for the reason that you have not claimed the difference between the two. You have claimed the entire amount that was coming, that you were allegedly paying to DVC. So
Yes.
that aspect is, Malaj, I am referring to in terms of mitigation of losses. The enunciation, Malaj, is succinct and it's to the point at para 74 at page 316.
Yes.
In addition, mitigation of loss, contrary to the argument of the claimant, need not have been pleaded or proved by the respondent in the first place. A composite reading of 73 and 74 of the Contract Act implicitly imposes the burden of proof on the claimant in respect of mitigation of loss, making it a prerequisite and an inseparable component for a claim of damages. In the present case, the claimant has not pleaded any such mitigation of loss, nor is there any clear finding in the impugned award to that extent. In fact, for a prolonged period, by virtue of the interim order passed by the court, the claimant was permitted to sell its end product without using the brand name of the respondent, thus impliedly releasing the respondent from the reciprocal commitment to be bound by the products manufactured by the claimant. The principle laid down by the Supreme Court in Messrs. Muralidhar Chiranjilal and the Bombay High Court in Autocraft Engineers are thus fully applicable in such context. Para 77. The Supreme Court has clearly set out the contours of interference with an arbitral award, holding time and again that the AT cannot lend an interpretation beyond the scope of the contract and cannot rewrite the contract. Maharaj, I've seen PSS Sickle, I'm not going into it.
Yes.
Ultimately, the award was set aside.
Right.
That, Manoj, brings me to judgments have covered of this honorable court. In addition to that, Manoj, I'm just relying on two judgments of two different courts. One is of the Delhi High Court. The other is of the Andhra Pradesh. The other is also of this honorable court, Manoj, the last judgment.
Yes.
But Manoj, may first have a look at the Delhi High Court judgment, page 319. Relevant paras are, this is again on the point of vital evidence not taken.
Right.
Vital evidence not taken into consideration and misappreciation or misreading. Paras 82 to 89.
All right.
At page 363, I'm referring to. This is a division bench order of the Delhi High Court, Manoj. No stay on it, although an SLP has been filed. But there is no stay. Page 363, para 82.
Right.
Moving on to the second material issue, whether the learned single judge erred in not examining the arbitral award passed by the learned AT under section 34(2)(a), leaving us to adjudicate any existence of patent illegality in the arbitral award. In our considered opinion, the impugned order and the arbitral award rendered by the AT would also have to be tested as to if they are falling into the vice of arbitrariness, perversity, or capriciousness, thereby giving an impermissible view, which could not have been reasonably arrived at by any person upon an ordinary application of mind. If the impugned order and the arbitral award fail the said tests, the same must be deemed to be liable to be set aside in appeal under section 7 of the Act. For this, let us make an effort to venture into what constitutes a patent illegality. Malaj, I'm not going into the law. 84, 85, Malaj have already seen. Sanyong. 86, Malaj have seen. Again, I am coming straight away to the factual point. Malaj, may please straight away come to para
87.
87, yes. in facts before us, the issue of patent, Malas have already looked at the judgments. I'm not repeating them.
Yes,
In the
yes,
facts
yes,
before us,
same
yes,
judgment.
the issue, yes, the issue of patent illegality involves applicability of provisions of Article so and so and so and so. In fact, Malas may straight away come to para 95.
Correct.
This is still continuing until 95.
It is.
I'm just referring to one judgment of the Supreme Court and then getting down to the what has been held eventually in the matter. 95. Interestingly, after conclusion of arguments in the present proceedings and reserving the judgment, we now also come across a very recent so-and-so. The term public policy has been interpreted by this court as meaning fundamental policy of Indian law, interests of India. This court further held that an arbitral award can be set aside as being contrary to public policy if it is patently illegal. The illegality must go to the root of the matter and must be so unfair and unreasonable that it shocks the conscience of the court. It cannot be of a trivial nature. Such patent illegality includes a situation where the award is in contravention with substantive law. Further, an award can be set aside as being opposed to the fundamental policy of Indian law if it is perverse, 34, that is, the finding is not based on evidence, or the arbitral tribunal takes something irrelevant into account or ignores vital evidence. However, an award is not perverse of the finding. Now, 96. Since we have already noted the applicability and scope of so-and-so, dealing with an appeal of present nature, as has been held by the Honorable Supreme Court in Choksi. Now, Malas, may please have a look at para 97 is where he gets into where the bench gets into the facts. And in fact, Malas, because the facts are very long and tedious, Malas may come to the penultimate part where they summarize. At para 117. At page 394.
Yes.
Therefore, in our considered opinion, knowledge of the Union of India with the reservoir connectivity could not have been deduced by the learned 80 by mere conjecture and surmises. Without adverting to the merits involved, we can say that RIL has extracted the migrated gas. However, the said extraction exploration of the migrated gas was without any express permission, cannot be said to have been in most efficient manner for betterment of the Union, which did not belong to it and which did not entitle them to reaping any profits therefrom. In view of the aforesaid, in our considered opinion, the view taken by the 80 was not a possible view, since the said view is not only against the dicta of Honorable Supreme Court, but it is also violative of the provision of any LP and the public trust doctrine and the fundamental law of the land, and is thus patently erroneous. In view of the above, the conclusion drawn by the learned single judge while disposing of the 34, what was comprised in the PSC was purely a commercial transaction entered into by two contracting parties, is correct. However, in our considered opinion, and in view of the aforesaid analysis and finding, the learned single judge erred in stating that the factual conclusion are perfectly rational, coherent, and logical. Since the said assertion was arrived at by the 80 after patently erroneous application of law, and as such, there did not exist a patent illegality on the face of the award. In view thereof, we respectively do not agree with the finding of the learned single judge that it was the other way and was not a possible view. Finding in conclusion, in view thereof, in our considered opinion, the view of the learned 80 that unless such an order is made, the claimant is not prohibited and is permitted to continue its petroleum operation within its contract area in a situation where the reservoir extends beyond contract area into another is patently erroneous against the fundamental law of India and against the public policy of India, more so being in the breach of the terms of the PSC and being the technical expert and having the know-how. It was the fiduciary duty of RIL to disclose the DNM 2003 report to the Union of India. As such, the view expressed in the findings expressed by the learned 80 in its arbitral award, query above, would be teeth of the objects of the NELP from which the PSC emanates. Accordingly, in view of the factual position involved, we find sufficient reason to interfere with the impugned order, dated so and so, especially after the findings of the learned 80 in the arbitral award where the proceedings interstate. That is, interstate the Union of India and RIL being an international commercial arbitration, as also since it is held in the impugned order passed by the learned single judge, that the learned 80 has taken a possible view. In any event, as elaborately discussed there above, we have found patent illegality on the face of the award worthy of interference. Based on the aforesaid detailed analysis and finding with the scope of section 37, we also find that there was a patent illegality on the face of the arbitral award. We have no alternative but to set aside the award. Then, Malaj, the last judgment on this file, on this matter, on this point. This is at page 398, and only one page is relevant for us. This was a case, Millets, where there was a claim without a proof. Prolongation claim, Millets, which are there usually at page 399, Millets, Miss C.
Yes.
Page 399 on top of it's an order of the court, Millets, at page 399. It is contended that the learned arbitrator passed his findings merely on the basis of the respondent present petitioner having not adduced any independent evidence through oral witness or documentary evidence. It is argued that it is the claimant which has to stand or fall on its own case on the basis of evidence and the materials produced by it. Hence, the premise on which the award was granted, that the respondent petitioner failed to adduce evidence, is not tenable in the eyes of law. When counsel for the petitioner takes the court through the entire award and seeks to impress upon the court that the arbitrator failed to attribute any reason or advert to particular evidences in order to substantiate the claim of the claimant, rather it is submitted that there was incongruity between the conclusion of the arbitrator and the prior finding of the award. One has come straight away to page 5 at page 402.
Yes.
I'm reading the third parameter. In claim numbers, however, in claim numbers 4, 5, 6, and 7, the claimant present respondent has sought for compensation under various heads, including on account of prolongation of the job beyond the agreed reasons for reasons attributable allegedly to the department. The learned arbitrator, despite holding that the delay could not be attributable exclusively to one party, granted compensation to the claimant arbitrarily without any material basis whatsoever. Similarly, the claimant failed to substantiate on the anvil of the test as stipulated in section 73 of the Contract Act as to the claimant having suffered any loss or damages on account of business loss and on account of amount payable in respect to the works executed under various items in excess of the 20% quantity incorporated in scheduled works of the contract. Awarding compensation to the claimant for excess work done by him over and above the dues thereof, as well as on account of business loss, without any substantiation of such claim by any cogent material, is perverse and as such contrary to the fundamental policy of Indian law. Even without going into detailed review or appreciation of evidence, it is palpable on the face of the award that the sums granted by the learned arbitrator on account of claim number 3 to 6 are perverse. So this is a classic case, Manoj, where just a calculation is given and no proof is given. And Manoj eventually set aside this portion of the award in the matter. Now, Manoj, coming to the second, coming to the aspect of interpretation. Now we shift to the third submission, Manoj.
Yes.
That even an interpretation which is perverse can be interfered with. It is not anymore a domain only of the arbitrators to interpret and also to interpret perversely. Illegal interpretation may perhaps still be within the contours, but a perverse interpretation is not. Manoj, may note the paragraphs.
Right.
It's 38 to 40, 46 to 48, 50, 51 and 54 and 67.
Yes, thank you.
And I will not refer to the same judgments which have already been read. So 38, 39 is covered. My lords already know this. 40.
Yes, but
in essence, the ground of, I'm reading at 417 minutes. In essence, the ground of patent illegality is available for setting aside a domestic award if the decision of the arbitrator is found to be perverse or so irrational that no reasonable person would have arrived at it, or the construction of the contract.
sorry, this is which paragraph?
It's para 40 minutes at page 417.
417 in my copy does not contain para 40.
I'm so sorry. Is it the same judgment, Manoj? Delhi Metro Rail Corporation?
Yes, versus Delhi Airport Metro.
Oh, Manoj may have a true copy. I may have a non-true copy. That could be the reason why.
In other words, an untrue copy.
Yes.
But Mr. Chandra, para 40 starts with what? Please repeat once again.
Yeah, in essence, it's immediately after Sangyong. After the enunciation in Sangyong, the very next paragraph.
No, doesn't.
39 in this.
39.
Page 424.
In essence, yes. Thank you.
Yes, Malaj.
But then all the paragraphs will back.
Yes, Malaj. This is the reason perhaps why Malaj. The Malaj have the original. Malaj have the true print. I have an online print.
No, but you have probably referred to the paragraphs in my copy because you
No,
started,
Malaj, yes, Malaj.
started with
So
para 38. So,
yes, yes. So
and this
Malaj
is
will
para
have to read it
39 in my.
38. Malaj will have to read it 38.
Yes, yes. Or
Yes.
Sangyang, yes.
Yes.
38 is
Af-
Sangyang. Yeah. Yes.
Yes, immediately after Sangha. In essence, the ground of patent illegality is available for setting aside a domestic award if the decision of the arbitrator is found to be perverse or so irrational that no reasonable person would have arrived at it, or the construction of the contract is such that no fair or reasonable person would take, or that the view of the arbitrator is not even a possible view, a finding based on no evidence at all, or an award which ignores vital evidence in arriving at its decision would be perverse and liable to be set aside under the head of the patent illegality. An award without reasons would suffer from patent illegality. The arbitrator commits a patent illegality by deciding a matter not within his jurisdiction or violating the fundamental principles of natural justice. My lords, may now please refer to straight away 46. In my lord's compilation, it would
46.
be
46.
there
Which
is
are-
fundamental error in the manner.
45 man.
Oh,
It's
achha,
45. 45. There is fundamental error in the manner in which this court.
Yes. Very.
There is fundamental error in the manner in which this court dealt with the challenge to the decision of the High Court. This jurisdiction of this court was invoked in 136. The court was exercising its jurisdiction over a decision rendered by the division bench of the High Court in Appeal under 37. The division bench had held that the award overlooked crucial facts and evidence on record that were crucial to the determination of the issues before the arbitral tribunal. This led to the award being perverse and patently illegal within the parameters of section 34, as explained in the judgments on Associate Billen and Sanger. The award overlooked the express terms of clause 29.5.1, which stipulates that if effective steps were taken during the cure period by the DMRC, the contractual power to terminate could not be exercised. This court correctly considered the CMRS certificate to be irrelevant to the validity of the termination. Interpretation of the termination clause by the tribunal was unreasonable. Interference with an arbitral award cannot frustrate the commercial wisdom behind optimizing the alternate dispute resolution merely because an alternate view exists. However, the interpretation of a contract cannot be unreasonable such that no person of ordinary prudence would take it. The contract, which is a culmination of the parties' agency, should be given full effect. If the interpretation of the terms of the contract as adopted by the tribunal was not even a possible view, the award is perverse. Clause 29.5.1i entitles the concessionaire to terminate the agreements if the DMRC failed to cure such breach or take effective steps for curing such breach within the cure period. Pertinently, the clause used two separate phases, cure and effective steps to cure. The clause reads as follows. I'm not reading the clause, Malaj. I'm coming straight away to para 50. Evidently, this could not have been the intention of the parties because they have clearly agreed to include the phrase effective steps. They clearly intended that once a cure notice was served on a party, it would be open to them to either cure defects or to initiate effective steps, even if they could not culminate into a complete curing of the defects within the cure period. Incremental progress, even if it does not lead to complete cure, is an acceptable course of action to prevent termination according to the 2008 agreement. The tribunal did not appreciate the individual import of the two phrases separately from each other. This was not a matter of mere alternate interpretation of the clause, but an unreasonable and an uncalled for interpretation of the clause, which frustrated the very provision and which no reasonable person would have accepted considering the terms of the clause. We must clarify that tribunal could have still arrived at the conclusion that the steps taken during the cure period were the steps taken during the cure period were not effective within the meaning of the clause for certain reasons. However, such discussion and reasoning is conspicuously absent. Issue H framed by the tribunal, just refer to 54 straight away, Malaj. The judgment of this court also never trusted the relevance of the CMRS certificate vis-a-vis effective steps. This court accepted a reading of the termination clause by the arbitral tribunal and the single judge that was not even a possible view and could not have been arrived at on any objective assessment. This court not only overlooked the plain words of the clause, but also rendered the phrase effective steps OTOs. The award overlooked the vital evidence and matters on records. Now, Malaj, may please have a look in this section. Malaj, may please have a look at page 50, 51, 54. Malaj may lead to 67 straight away. at page 425.
It starts with
In essence, therefore, the award is
Yes.
unreasoned.
yes.
In essence, therefore, the award is unreasoned on the above important aspects. It overlooks vital evidence in the form of joint application of the contesting parties to CMRS and the CMRS certificate. The arbitral tribunal ignored the specific terms of the termination clause. It reached a conclusion which is not possible for any reasonable body of persons to arrive at. The arbitral tribunal erroneously rejected the CMRS sanction as irrelevant. The award bypassed the material on record and failed to reconcile inconsistencies between the factual averments made in the cure notice, which formed the basis of termination on the one hand and the evidence of the successful running of the line on the other. The division bench correctly held that the arbitral tribunal ignored vital evidence on the record, resulting in perversity and patent illegality warranting interference. The conclusion of the division bench are thus in line with the settled precedent, including the decision in associate builders and SAT. Finally, Maharaj, in conclusion, they set aside the judgment in para 71. The judgment 68, the judgment of the two-judge bench of this court, which interfered with the judgment of the division bench of the High Court, has resulted in a miscarriage of justice. The division bench applied the correct test in holding that the arbitral award suffered from the vice of perversity and patent illegality. The findings of the division bench were borne out from the record and were not based on a misappreciation of law or fact. This court failed, while entertaining the special leave petition, to justify its interference with the well-considered decision of the division bench of the High Court. The decision of this court fails to adduce any justification bearing on any flaws in the manner of exercise of jurisdiction by the division bench under 37. By setting aside the judgment of the division bench, this court resorted to patent illegal award, which saddled the public utility with an exorbitant liability. This has caused a grave miscarriage of justice, which warrants the exercise of the power under 142 in a curative petition in terms of Rupa Hurra. The curative petitions must be and accordingly allowed. The parties are restored to the position in which they were.
You can move on to the next judgment position.
Yes. Yeah.
Yes.
Next, Maharaj, is yes. Then, Maharaj, then is the point and the concept of fraud, Maharaj, which is what we started with in the peculiar facts of this case, because frankly, Maharaj, this aspect of fraud was not visible to us at the time when the matter was going on. And this is an aspect which came into existence only post the matters were reserved and at the time of pronouncement. So we could not have said anything of that sort during the arbitral proceedings.
This
We
pertains to
got-
the award itself, passing of the
Yes.
award.
Yes, Maharaj.
You
Yes.
should not have taken it early.
Yes. So therefore, anything that we could have said has been said in 34. There was no opportunity for us to say it prior in point of time, at the time. So it's not a classic case of fraud, Maharaj, where there are judgments replete, where they say that if something has been not divulged to the arbitral tribunal,
Yes.
and which will have a material bearing, would constitute fraud. But this is peculiarly on the very making of the award that we say is fraudulent, is what we are
Rather intertwined with section 31 also.
It is also intertwined with section 31 also, Maharaj.
Yes. Yes.
But greater to that, Maharaj, the factual basis that I had initially put, the mental state of the learned judge, the learned arbitrator, the way in which the award itself is dealt with, the way it is dealt with in the first tense, whereas the person, Maharaj, was in the hospital. He was discharged only a day back, and for prolonged period of two months each, he was inside the hospital and not in a state of mind to actually write this kind of an award. And the way it has been written is in first person. It is really on that, in that factual context that we are dealing with fraud. So, Maharaj, this judgment that I am citing is only on perhaps the basis of the standard of proof, or whether the court can look into on its own the aspect of fraud in the making of the award.
All right.
This is more on that point, Maharaj, because the fact of the matter is completely different here. Fraud was already adjudicated. The court had already pronounced a judgment that it is fraudulent. The company then obtained an award, and the argument that was raised was that where an NCLT has pronounced the very existence of a party to be fraudulent, any transaction that is done by the party is also fraudulent.
The language of the explanation of 34 to B
Yes, Manoj.
is that the making of the award was induced or affected by fraud?
Yes, Manoj. Yes, yes, yes.
Induced might relate more to the during the arbitral proceedings because the award was induced by that fraud.
Correct.
But affected by fraud hits the award directly also. So you may argue on that. Yes.
Manoj, our argument primarily will
Award
be
is
on the second.
itself affected by fraud.
Absolutely, Manoj. Absolutely. That's the argument there because induced, I couldn't have said
No, induced means during the proceedings.
during the proceedings
Apparently, yes.
where
Yes.
something was concealed or something was told or some
It is
misrepresentation
induced
was
into
made.
doing this. But this is
Correct.
directly the award is affected by fraud. That
Correct,
is the
correct, correct.
case.
Correct, Manoj. Correct. So it's on that point.
Or
I am
also
citing
maybe
this judgment.
somewhat
There is-
corruption. I mean, corruption is a wide term.
Yes.
Not corruption, not up to that level.
Not, Manoj, since we can't, unfortunately, since we don't
Corruption is
have,
a very, I mean, wide term in a sense. I mean, it's very subjective also.
I agree, Manoj. I agree. I mean, I until we don't have anything
No,
to suggest that, I can't make an argument, Manoj, in law there.
no, definitely.
I can't say that, look, I have this material, it is pointing towards that. What I can say is that this completely is what I can say is that this completely is fraudulent to the extent of not only intellectual fraud, but also non-application of mind and passing something to be correct.
All right. Yes.
That's really the argument there that we are stressing on in the first leg of our argument, Manoj, which is where I took this honorable court through extensive medical evidence also.
Yes, yes.
Now, Malaj, may I please have a look at paras. In this, therefore, Malaj, my submission is going to be very limited in this particular judgment. Malaj, may I please have a look at para 10 first, how the matter came about. And then I will straight away take my lords to the portion. Malaj, may I first have a look at page 10, para 10 at 432. So what had happened here was, Manoj, one of the parties was the existence of a party was pronounced as a fraud, that it has been incorporated for a fraudulent objective. In the process, they obtained an award between the two parties. This is a section 34. This is a section 37 from a 34. 34 court hold that yes, if your existence is fraudulent, anything that you achieved out of your existence is also fraudulent. The argument that was raised before the division bench was that, look, none of this was raised in a section 34 petition. No argument of fraud, nothing. This has only come by virtue of a judgment of the Supreme Court. Therefore, you can't today claim that it is fraudulent. So the court goes into the aspect that whether the court can itself look into any indication that is fraudulent or not under section 34 2 capital A. So there, in fact, the court says yes, irrespective of the parties saying it, even the courts can look into it suo motu on its own.
So the order 6 rule 4 sort of principles CPC, those
Perhaps
are diluted.
Perhaps diluted, Malaj, to the effect that it's like a case of land engineering where the Supreme Court says that, look, matters of limitation, matters of jurisdiction, matters of subject matter jurisdiction is something that is to be gone by the court by itself. No party needs to sort of, say or state.
Yes. Yes.
So it is elevated, Malaj, to that extent that if the court looks at it or finds it to be fraudulent, the courts can itself also look into it. Malaj, please have a look at para 10. And there is one judgment of the Singapore court of the Supreme Court that I will cite, Malaj. I don't have it right now.
All right.
It is not with my colleagues and therefore with the bench.
We have it.
Your colleagues have it.
They have it. Okay, Malaj. That's good. Great. So I would first finish this, Malaj, and then get to that.
We won't have the time to cite the Singapore judgment today, though.
Of course, Malaj.
We have
So
2 minutes left.
can we do this? Can we do this, Malaj, on the next day, with whatever is convenient to this on?
How many paragraphs of this Devas would you
Yes,
be
Malaj.
citing?
I will indicate, in fact.
You just
para
indicate the
10.
paragraphs of Devas, yes.
Yes. Para 10. And then, Malaj, para.
Your para 10 starts with while the proceedings under section 34.
Yes, Malaj. Yes. That's the factual. Malaj have the same copy.
Yes, they have the same.
Both of us have an untrue copy.
Yes, right. Both of us have an untrue copy.
Para 10, then Malaj may straight away look at paras 109 and 110. And then from 115 to 120, 115 to 123. And the next two judgments that are there in the compilation merge are only
Yes.
on the point of business efficacy.
Ah.
The interpretation and a contract of business efficacy, Nabha power is really the locus classicus there. It defines what is business efficacy. I'll just take my lords through those.
All right.
Additionally, on fraudulent, my lords, on fraudulent
Yes.
point, I will just give a few more judgments. One is a Singapore judgment. There are two other judgments, and there is one other point that was canvassed but not in that great detail of section 16 and 19 of the Sale of Goods Act.
Hmm.
I will elucidate on it on the next hearing whenever.
Then you can have a very small supplementary component.
Yes, very small, Malaj. Nothing, not like a 500 page, perhaps like a.
But the outcome of this section 34 may be inversely proportional to the size of your.
No difficult. No difficulty.
So that's a caveat I put all my counsel on.
No,
Yes.
Malaj, no difficulty at all.
Thank you.
I'm obliged, Malaj. I'm obliged for the patient care.
appear.
Yes.
But I am in a dilemma, my lord. My appeal has been disposed of. Against that, my lord, they have gone up in Supreme Court. Notice has been issued. My lord, my clients have gone away. How will I appear? I don't even have a wakalatnama, nothing, my lord. How can I appear, my lord? I have a difficulty.
The only thing is why we thought, because the Supreme Court has adjourned the matter waiting for a finding from this court, in
Yes.
this bench. And you are successful before one of the learned
Yes.
judges. So
To know your version.
unless
I
the
could have
order-
argued, my lord, provided my client would have instructed me, because I can't argue, my lord, without an instruction or a wakalatnama. Yes,
Yeah.
that lordship does, my lord.
We are appointing you as amicus curiae. And we'll start this as a trend. Conflicting interest. No, that will
That
help.
is why, my lord, I
Administrative notice
না
for-
পাগল হচ্ছে না এরকম না সুপ্রিম কোর্ট বলেছে 3 মাস না 6 মাসের মধ্যে 4 মাসের মধ্যে করে সে পিরিয়ড ওভার হয়ে গেছে
ও তো প্লি নেবে যে আমাকে না শুনে করছে এটা
Did you file any written notes of arguments in the do you have a copy of that?
I have it here. I can, my lord, file it. I have a written notes on argument.
একটা নোটিশ কিন্তু আমাদের দেওয়া উচিত
না না এরকম
আর বাকি কোথায় গেল
এদের কারোর পয়সা দেবে না কেউ করবে আর্গুমেন্ট ক্লোজ করে দিয়ে যাচ্ছে
one party will be unsuccessful. The first three
না this is a reference this is a reference
reference
Difficulty, my lord, which will appear is correct. What my lord is saying is that before the Supreme Court, when this matter goes back, whatever be the decision,
one of the parties will be agreed. So they
they will say that no notice was given. That's the difficulty, my lord.
but you appeared for your client in the
I can argue always, my lord. It will be a privilege to argue, but my lord, my clients are not on notice. So, my lord, I can't, my lord, take it up on my own.
your advocate record is here
No, from Andaman. Lordship gives him a notice, then I can, my lord. That I can do, my lord. He's put on notice, my lord. Then that lordship can, my lord.
Mr. Chatterjee and Mr. Dwivedi were for one of the parties successful before Justice Bhattacharya or unsuccessful. Unsuccessful. So the only your client.
I was successful, yes.
no before me Mr. Aniruddha Chatterjee and Shatadru Chakraborty were there for this
Yes.
So now Mr.
He wasn't, my lord, in my matter.
and in your matter before Justice Bharadwaj you were there
I was the applicant. Appellant,
other side was
the
someone
other
else.
side was, yes, someone else. But I have the name, my lord, with me. I can give that name. And that, and from that only the SLP has been preferred.
Chatterjee, do one thing.
Supreme Court direction
You make your submissions today.
I was told the
Surprise hole.
union would do.
Huh?
Union would.
Okay, we
Huh.
start with the union.
Yes.
We will continue with the hearing and we'll give you notice to your.
সেটা থেকে তো SLP করেছে।
তো দিয়েছে হ্যাঁ এই যে রাজশ্রী
Right, we understand. it.
রাজশ্রী expedite to expedite the hearing এটা আছে হ্যাঁ তা শুরু করতে ইউনিয়নটা শুনে নিয়ে আজকে শুনে
Mr. Kormokar,
Okay,
you may start.
Then, my lord, I can leave.
Today you leave, but please,
Argument না শুনলে তুই উত্তর দিবি কি করে?
আমি যেন ফাঁসাচ্ছি জানি না।
ওর মক্কেল নাকি ওকে এখনো এনগেজ করেনি।
Sir, not in game, my lord. He doesn't even know about this proceeding. He's not even.
All right, all
এটা তো
right.
মক্কেলের এনগেজমেন্ট নাই, this is for the
এইটা না।
আমার
in
কাছে
this
তো আপনার
proceeding
বললাম।
was not
ঠিক আছে, we will give a notice.
Even my records have to be called for, my lord, because my records are not before my lord.
আইনের আবার রেকর্ড
I don't.
Reference.
Whatever, me, my lord. My records are not before my lord. Gives the notice to my client.
We
my
will
lord,
give you
Then I can come back.
law purely
purely on a question.
notice to your client. Yes, Mr. Kormokar, you may start.
সে বুঝবে না।
Lordship, may I please, Lordship?
Lordship is not going to sit today.
থেকে বাড়ি চলে যাবে।
It was from 3.
দূরে ফোনে
না, আমারই ম্যাটার আছে ওই জন্য। সেই জন্য মাসটা আমারই matter।
Yes, yes.
on the question of the law হ্যাঁ
বলবে না?
আমাদের কাছে ম্যাটার রেফারেন্স হয় না আমাদের কাছে শুধু কোয়েশ্চেনটা রেফারেন্স হচ্ছে কোনো দরকার
ভুল দিলেই হয়ে যাবে।
রেগুলেশন গুলো যেগুলো আছে যা যা
Text records লাগবে না।
সিকোয়েন্স লাগবে না
Yes, Mr. Kormokar.
Lordship, may I
Yes, sir.
please, Lordship?
yes yes
you may.
please
In affirmative for Lordship, which was preferred by the plantation, kindly come to the page number 19, then in which point it was referred to the larger bench, Lordship.
19.
we have the reference before us what
Law-
is your argument on that
Lordship,
on
that's
the law point
Lordship. What happened, Lordship? one civil suit was filed before the Civil Judge Senior Division, Port Blair, Lordship. The administration has filed a petition under Order 7
Mr.
Rule.
Kormakar, we are on a different footing here. We are not hearing the parties on their respective cases, right?
Lordship,
The only question of reference is whether the learned district judge at Port Blair, Andaman and Nicobar Islands has unlimited pecuniary and territorial jurisdiction to hear appeals from all judgments, decrees and final orders of all subordinate courts within the Andaman Islands by virtue of notification number 78/54 dated August 8, 1954, issued by the Chief Commissioner. Since the operation of the Bengal Agra Assam Civil Courts Act does not extend to the union territory of the Andaman and Nicobar Islands.
Lordship,
Address us on this question, just the law points. If you want to rely on notifications which have the force of law or
Lordship,
the
Lordship.
acts, please argue on that only.
That is notification 8 November 1954, Lordship. I have 1954. There was a notification.
8 August probably.
8 November.
Place that before us, yes.
Lordship, may I read, Lordship? Just
Yes, please, yes.
We require a copy of that also.
Lordship, I have a copy, but within the record that was not placed earlier occasion, Lordship.
All right, yes, please. Continue.
Lordship, may I read, Lordship? In exercise of the power conferred by Section 2 of the Andaman Nicobar Island Civil Courts Regulation 1940, Regulation 9th of 1940, the Chief Commissioner of the Andaman and Nicobar Island hereby establish a court of the district judge for the Andaman and Nicobar Island as the principal civil court of original jurisdiction within the Andaman Nicobar Island, with jurisdiction to hear appeals from the judgment, decree and final order of all the subordinate civil courts within the Andaman Islands. This is the notification, Lordship.
Yes.
This is the notification.
Hmm.
As per notification, civil judge, district judge has the first appellate court, Lordship.
Yes.
As per the notification, district judge is the first appellate court, Lordship. This notification is here. We follow this notification, Lordship.
Hmm. And how would you say that the Bengal Agra Assam Civil Courts Act will not be applicable? What is the extension of that act?
Lordship, that because this here, Lordship, Andaman Nicobar Island civil courts also established by the notification, Lordship. Civil courts also established, appellate courts also established civil appellate court. That was also established by notification.
Whether that notification was derogates the Bengal Agra Assam Act, and how far is the applicability of Bengal Agra Assam Act in the Andaman Islands?
You know, as per my knowledge, Lordship, that is not applicable. We have to follow this notification, Lordship. We have to follow
Mr.
this.
Shatadru Chakraborty is still there on the panel, Mr. Kormakar?
Lordship, panel, sometimes he used to appear through BC, but not coming physically to Andaman, Lordship. Sometime in cases, earlier he used to appear in these cases. Just newly I have been assigned, Lordship.
That looks to your lordship's judgment in my matter.
Yes, so that's it. You are saying because of the November notification, how the civil court was established, that is what is applicable. Nothing else is applicable, right?
Lordship, that is my submission. That is my submission.
You- Yes.
Takes up the judgment of my lord Justice Bhattacharya.
Yes, I have.
Sequentially, it's been given why it's not. I'm basically agreeing to what they are saying, so I don't want to trouble your lordship further. What I need to show your lordship is why Justice Bhattacharya's judgment did not take that into consideration. That is the only
I
point
think
of.
that is because Justice
Lordship was not shown these notifications.
So we'll do one thing. You are principally sorry. The notice দিবি নাকি? That. একটু order টা
But what
লিখে
they
দিন।
would need as well, along with the notice, is these notifications as well as the act also. So we will, my lord, I would suggest that because we are agreeing with the.
না তো হতে পারে না, কারণ সুপ্রিম কোর্ট তো ওর appeal এই order টা করেছে।
হ্যাঁ, ওরা পেলে ওটা
এই
করছে।
ঠিকই। Yes,
পয়সা দেয়নি কি তার?
হ্যাঁ
Milord directs us,
অনেক টাইম
Milord, to make a
রাজস্বী
compilation and
orderটা
give it to
কোথায়?
the other side.
Will you send the notice to them?
I'm saying so, directs us. Directs us. We'll
the
do
notice
it.
also.
My lord.
Where is
Notice along with the notifications and the acts as well,
এর orderটা
along
কোথায়?
with your lordship's order and my lord's order.
Best.
Then,
যেটা
Milord, they will
ইয়ে,
not be in
Justice
on the next
ভরদ্বাজের
day, they
order।
will not.
Not taken by separate.
এটা তো জাস্টিস ভট্টাচার্যের অর্ডার। Where is Justice ভরদ্বাজের order? হ্যাঁ এটাই FAT 3 of 22 is theirs না?
FAT, yes, Milord. Yes. 3 of 22, Robin Bucks.
আমি বলছি বাপি এই যে রবিন বাগচি ভার্সেস এই যে রবিন বাগচি এদেরকে নোটিস করে দিক।
নম্বর হচ্ছে পরের দিন
তোদের ইয়েটা পাবে কোথা থেকে?
statutes and
I'll get it from
Where will you get that
I'll get it from the
address?
Milord, the কি app ওটা যেখান থেকে পাওয়া যায় সব,
you can have
the High Court's
সব সার্থক
also.
এটা পাবি না।
He had produced everything.
If you ask
and
him, he'll definitely
I'll do that. I'll do
he'll
that.
give the soft copies.
I'll do that. But I don't know why he's not appearing.
He's resigned from the panel.
He's resigned.
আচ্ছা এই FAT 3 এর সব কাগজ আমরা আন্দামান থেকে পেয়েছি।
দরকার কি আর দিলে হবে?
দুটো জাজমেন্ট থাকলেই হলো তো আবার কারণ
না
Cost title দরকার। I'll get that from the High Court's app.
এটা খালি শর্ট কস্ট।
ওহো
I'll get it from the High Court's website.
এই ভলিউমটা কি খালি FAT 4 যেটা মাই লর্ডেরটা? FAT 3 এর কপি আছে?
শর্ট কপি আসেনি
ওখান থেকে বার করে নে না। কি আন্দামান থেকে ওটা বল না বার করে নে।
টেস্ট হয়েছিল। আচ্ছা আমি গিয়ে খবর নিচ্ছি, এটা লিটিগেশন এসেছিল।
লিটিগেশন কমিটিতে তোমাদের কমিটিতে
আচ্ছা শতরূপকে বললেই তো।
ডেফিনেটলি টেস্ট হয়েছিল। আচ্ছা ঠিক আছে। Mr. Aniruddha Chatterjee, Mr. Kormokar, learned advocate for the Andaman administration, conclude these arguments. Mr. Aniruddha Chatterjee represents the respondents though. No, you
No,
are
we were the appellants there.
appellant in FAT 4 of 2025. It has been brought to the notice of this court that the parties in FAT 3 of 2022 are not yet on notice. The bench had requested Mr. Shatarup Banerjee, learned advocate representing the appellant in FAT 3 of 2020 to address the court, but Mr. Banerjee has expressed his difficulty. Under such circumstances, we deem it proper to direct that a copy of the extract of the reference along with relevant documents, notifications and orders of the court passed in FAT 3 of 2022 and FAT 4 of 2025 be served upon the parties to FAT 3 of 2022. Be served. You will serve.
I'll serve.
Thank you.
By the advocate on record for FAT 4 of 2095.
Serve করে দিই।
In FAT 4-5.
The only thing that we need, Milord, is the address.
FAT 3
Is
I think
address.
is there in our I'll find it out. We'll find it out. Otherwise, we can ask the কাগজটা পাঠা
দেরি হয়ে
বলে দিই না দেরি we will start the process. হ্যাঁ
রশিদ আলম তো আছে তোমার
yes আমাকে বন্ধু ভালোবাসে তো এরকম করিস না।
I overheard that.
The records of FAT 3 of 2022 be placed before this bench on the next date. Department is to take expeditious steps to ensure that the records are brought from Andaman immediately. From Port Blair. Circuit bench at Port Blair immediately.
2 weeks, Milord.
12 তারিখ?
কবে রাখবো
12 তারিখ?
অসুবিধা আছে 12 তারিখ হলে কি বলছিস
শুক্রবার? ঠিক আছে 12-12
2 PM রাখবে নাকি 3 PM?
And the only thing, look, if we have the address of the parties in the other litigation, it'll be easier for us, Lord, to send it
এটা
immediately.
ছাড়া আর কোনো ফাইল আসেনি না, এটাই তো এসছে না।
If I can, Andaman থেকে
মিস্টার কর্মকার,
Lordship.
why don't you take an inspection of the file of FAT3 of 2022?
Lordship, I have copies. If FAT3, I have a copies. I
তাহলে
have
তো
gone
খুব
through
ভালো
it.
করতে।
Then can you share it on screen?
Lordship, at this to take time, Lordship. If I may be directed, then I can provide
that-
Lordship.
Can share it on the screen?
Not
Impossible.
Lordship, now, Lordship.
Now can you?
Please share it on the screen then.
You bring the data entry operator, we'll wait for you.
Lordship, I have to then.
No, you go and bring him.
Lordship, just.
We are waiting. We don't have anything else because we are waiting for you. We have kept this matter and we are.
পরের দিন আবার
ঠিক বলছি, আবার তাই।
3টে রাখো তো, 2 PM করে, তারপরে আর
3
কিছু
PM,
করা
3.
3 PM, হ্যাঁ।
Lordship. I will come with the FAT3.
We are waiting for you. Yes.
Lordship, within 10 minutes, Lordship, I will.
All right,
10 minutes.
Lordship.
Then we rise and come back. Or
Lordship, within the file, Lordship, big file, I have to search that, Lordship.
আরে cost title টা
We need the cost title, the full
Lordship,
cost
just a
title.
minute.
so
I am
that we
handing
can-
over to my agent, Lordship. Just a minute,
হ্যাঁ,
Lord. Sorry for. Shekhar.
আলমারি পেছনে?
কি বলছে?
না না, that's a door.
it's a virtual door.
No, that is the cubicle in the bench.
Yes.
The
There are several cubicles.
yeah.
10 cubicles now in
In
Andhra.
Andam?
Yes, this
You can
kind
contact
Okay,
all
that is-
district courts throughout the.
niche, downstairs.
Lordship, may I permitted to go outside the cabin and search from the file, Lordship?
Yes,
Yes, sir. You're getting 2 minutes for that.
Lordship.
কেন না যাচ্ছিস?
2 minutes বলে 10 minutes.
ভয় পাইয়ে মানুষদেরকে
ববিতা
কর্মকার কি কোনোদিন শুনেছো?
না, একটা পুলিশ সবাই বললাম
না, আসতে পারবে।
কিন্তু ওই অর্ডারটা থাক, তুমি যাই দিক রেজিস্টার থেকে একটা ব্রিফটা
FAT3 of 2022 টা যদি পাওয়া যায় এখান থেকে তাহলে আনিয়ে নিতে হবে।
এখানে যদি পাওয়া যায় পাস, নাহলে ওই অর্ডারটা
রেফারেন্সের কানেকশনে যে আসলে এটা রেফারেন্সটা হয়েছিল যেহেতু এটাই সেহেতু এই ফাইলটা শুধু দিয়ে করে পাঠিয়ে দিয়েছি, কনসিডার করে বেঞ্চ পাঠিয়ে দিয়েছি। কি?
রাশিদা
ওটা তো এটা আফটার থট, যেহেতু আমি তোমার ফেভারিট দিন আফটার থট ব্যাকলেস
এগুলো কথা বলছি না জাস্টিস সম্পাদক তো পাল যাচ্ছেন পরের সপ্তাহে, আগে কত কি বলবে, কিন্তু ওখানে মুশকিল হবে, দুজন
জাজমেন্ট
কোথায়
তোর কাছে
হারিয়ে যাবে।
রেকর্ড নেই?
আরেকজনের জজটা কোথায় থাকবেন? তুই
জাজমেন্ট
3টে জজকে নিয়ে যাচ্ছিস,
ওটা
দুটোই গন্ধ আছে।
আমাদের ওইখান থেকে আমি পেয়ে গেছি, অর্ডারটা পাবো।
কে তোমার রেজিস্টার কে আছে মনে আছে ওটা?
15 কিলো
হিমশিম কিছু খাচ্ছে না, আর দিতে
তো
চাই।
ওই নোটটা তো আমি দিয়েছি
তোমাদের কাছে থাকবে, তোমাদের কাছে থাকবে কিচ্ছু আমাকে আমার গুলো পাঠিয়ে দিতে পারো যেগুলো আমি তোমার যেগুলো
চলে গেল তো, বার করে দিলে কেন?
না, আসবে
But there is another Kormakar here, my lord, your lordship.
You have more control over him than us.
He's still stealing your SCC online thing.
My lord, they have stolen everything. Somebody's,
That's my right.
because they've stolen my
This is right.
fridge,
I
my
agree with Mr.
television.
Kormakar. This is right.
Lordship, not finding, sorry, Lordship, not
Not filing?
find in the file.
Finding, not
The
finding.
memo of appeal is not there.
I did not find, Lordship, FAT3.
Eh?
I did not find in my file, Lordship.
The record থেকে বার করে দিও।
All right. ওটা let me see if you can আমি আনিয়েছি। I'll share it with you.
I also.
Anything your lordship gives me, I'll give it to them.
Yes,
They'll
yes,
send it the next moment.
ঠিক আছে, okay.
চলো চলো চলো।
Early Friday.
No. Sit after this.
আবার
Must be some matter of yours in my single list.
সিঙ্গেল বেঞ্চ আছে পরের দিক।
ওটা তারপর একবার তুমি কথা বলো।
Grateful.
Grateful, Lordship.
আমি তখন বুঝিনি কে এসেছে।
ডেকে নাও তো একবার, অরিজিন সেটা কল করেছে কিন্তু কিন্তু শুনুন।
Well, I believe your lordship's list says till 3:30.
রাইট 3:30. Oh, right, then we'll continue.
Yes, I think it's till 3:30.
Already ডেকে নাও। I'll just sit in 5 minutes. Let them come. Okay, ডেকে নাও। Just give me 10 minutes, Mr. Mukherjee, or rather the officers 10 minutes.
Yes, yes.
So
of
they can
course.
come in. There was a misunderstanding because we thought this matter would continue.
My lord,
So the thing has gone
I was
topsy.
told, my lord, before recess it may not continue because Mr. Shatarup Banerjee told me.
Yes, that was the impression given by me only. But you are ready in your matter. You'll do your matter.
Yes, my lord, my learned friends have to conclude that stock exchange. And
You
my
will do
lord,
your matter.
yeah.
So very well. We'll just sit in 10 minutes and take up
Obliged.
the ordinance matters first. Then from 3:30 we'll, as per our list.
বেরিয়ে যাচ্ছে
Yes. I'll tell. শুনছি তোমাকে টাকা দিতে হলো। না জানি অঙ্ক তোমার সাথে দেখা হলো তারপর কোথায় চলে গেল। ইয়েস, আমার নোটস গুলো একটু দিতে বলো অঙ্ক। ওই তো এসে গেছে যখন পেয়েছি 5 মিনিট ফাটাফাট 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 আগের দিনের নোটস বাস হয়ে যান। থ্যাংক ইয়েস মিশন
দেবে
চলে
করবে করবে করবে
2018 সাল
হুম?
2028 সাল
হ্যাঁ কি পয়েন্টে হ্যাঁ তো ছবিটা তো মানে আই এম রেফারিং টু মানে
ইয়েস
2008 17 SCC 491 মানে
Right.
this is valid for the proposal এটা তো দেখানো হয়নি 54 টা দেখানো হয়নি sorry মানে may I just show one more মানে then মানে 2005 4 SCC 456
ইয়েস
no তাকে দিয়ে দাও and again on the point of disputed question of fact mallet kindly have a look at paragraph 19 mallet
ইয়েস
from the aforesaid, the legal principles that emerge are that the High Court, while exercising its jurisdiction under Article 296 of the Constitution, does not sit as an appellate authority over the acts and deeds of the financial corporation, seeks to correct them. Doctrine of fairness does not convert the writ courts into appellate authorities over administrative authorities. In a matter between the corporation debtors, the writ court has no say except in two situations: that there is a statutory violation on the part of the corporation, or where the corporation acts unfairly or unreasonably. In commercial matters, the court should not raise their judgment for the judgments of the bodies to which the task is assigned. And unless the action of the financial corporation is malafide, even a wrong decision taken by it is not open to challenge. Here there is really no allegation of malefides on the part of the respondent, the Calcutta Stock Exchange. But what they are saying unreasonably, unfairly. But again, I have tried to establish through the facts of the case, that they were always aware, they had all chances and reasoned order that I have already. Now, only one judgment on this is the this is that part of the judgment list, where is the point which I'm taking as a matter of record, that interlocutory relief cannot be beyond the final relief. It's a very technical point, I'm taking it because has seen what is the scope of the final relief in the writ petition. There has not been any amendment of the writ petition. The general application is in the nature of an interlocutory application. It is beyond the scope of the final relief. So, only one small judgment on this, Ashuk, 2008 17 SCC 491. Settle করে দেওয়া ভালো। And your Lordship will kindly go through paragraphs 10 to 20, And the objects and everything is more or less set out why pleadings are necessary, And then,
10 is irrelevant. 10 is irrelevant in the context. Para 10 to 20 you said.
and 12 onwards, sorry, 12.
12.
Object of pleadings,
Yes.
kindly see 11, my lord. But any anxiety to cut the delay or further litigation should not be a ground to flout the settled fundamental rules of civil procedure. Be that as it may, we will briefly set out the reasons for the aforesaid conclusions. And my lord,
So therefore 10-1 also.
10-1, my lord.
10-1 and 2.
2 also, my lord, and then 11.
Very good. 10-10 I'll take. Yes.
So, my lord, this is what I'm, my lord, if the main pleadings, my lord, do not contain
10 to 12.
10 to 12, and then thereafter, my lord, also, my lord,
Yes.
13, 14, and straight away, if your lordship kindly comes to, my lord, paragraph 13, my lord. Objective issue is to identify from the pleadings the questions or points required to be decided by the courts so as to enable parties to let in evidence thereon, and the facts necessary to make out a particular claim or to seek a particular relief are not found in the plain. The court cannot focus the attention of the parties on its own attention on that claim or relief by framing any appropriate issue. As a result, the defendant does not get an opportunity to place the facts and conditions necessary to repudiate or challenge such a claim or relief. The court cannot, on finding that the plaintiff has not made of the case put forth by him, grant some other relief. The question before a court is not whether there is some material on the basis of which some relief can be granted. The question is whether any relief can be granted when the defendant had no opportunity to show that the relief proposed by the court could not be granted. When there is no prayer for a particular and no pleading to support such a relief, the defendant has no opportunity to resist or oppose such a relief. If the court considers grant such a relief, it will lead to miscarriage of justice. And no amount of pleadings. Now, my lord, the point which I am trying to make out is, my lord, the original application does not make out a ground.
The writ petition.
The writ petition.
So now aren't you hearing the writ petition?
Yes, we are, my lord. I am saying, my lord.
So why you started with the interim relief cannot be beyond the final?
Because, my lord, he has made his main prayer now is in the GA.
That.
But I said that I will take this as the last point, your lordship remembers. I know your lordship's views.
The writ petition is before us also.
Yes, but
there is no amendment in the pleading.
Yes. And for that, my lord, may I just rely on a judgment, my lord? This is reported in 2003, 4 Company Law Journal, 333, my lord. This would be paragraphs 7, then 16, and then 22 to 33. And here was a case where writ petition was filed. At every instance, my lord, supplementary affidavits and my lord, nature of the writ was being changed. So where, my lord, this court held paragraph 33. Straight away going to paragraph 33, my lord. I know, my lord, but
yes,
I wouldn't mind a decision from your lordship on any of the sides or on this judgment, my lord.
On any of?
On this judgment.
Yes.
My lord, this is very unclear for me also, my lord, whether this should be accepted or this shouldn't be accepted. I'm going off the record.
Division bench, I have to.
Division bench judgment, my lord. So all these documents were filed after filing of the writ petition. And on the basis of these subsequent documents, supplementary affidavits, an entirely new case was sought to be built up, which was never put up in the pleadings. We shall deal with all these ones subsequently. At present, the question is whether this kind of procedure adopted by the writ petitioner before the learned single judge for developing a new case by filing supplementary affidavit should be accepted or not. Yes. We are conscious and writ jurisdiction provisions CPC with regard to pleadings are not required to be strictly adhered to. But the basic principle of law of pleading has to be kept in view. Writ petition cannot be dear the minimum pleading. In the present case, we have pointed out the entire case put forth before the learned was on the question whether JCL comes within the meaning of strategic sector or not. Prayers were also made to this effect, as reproduced below. But by way of supplementary, all these new pleadings were sought to be included. This mode cannot be countenanced. The petitioner wanted to challenge the entire process, selection of promoters in this disinvestment process, the binding on the writ to amend the writ petition and incorporate all these grounds. The peculiar method was adopted by the writ petitioner to bring out a new case by filing supplementary and annexing documents from time to time to make it impossible for the court as well as for other parties to meet the case of opinion. We cannot approve of this kind of practice.
You are given sufficient notice and we are hearing you on the GA also.
Yes.
Technical.
It is technical. Why?
Premise is that you have to be given an opportunity of addressing.
One is that premises. Next is whether, I also read the earlier judgment.
Court judgment is on a civil court second appeal. So in a civil court, yes, evidence is to be laid and other things are there.
Here also, with humility, I say, your lordship.
GA brings forth the new facts.
GA
brings forth the documents.
New prayers.
Petition is not a suit after all.
It is the original pleadings and interlocutory pleadings. GA generally, the GA, and your lordship knows the writ court rules.
You are not taken by surprise as such because we have been hearing it.
No, definitely not. I have not been taken by surprise.
And it's a
but from the very first day, I have taken this point. From the very first day, I have taken this point. It was for them to, whether they want to do it or they don't want to do that. But the point is, whether it is, because your lordship will kindly also appreciate, the CPC is incorporating the writ rules.
Principles.
No, the writ rules also under Rule 53A incorporates to the extent it is not at variance with the writ court jurisdiction.
Just read the language once.
I will just, may I just get the writ rules? Yes. So, as far as I remember, I'm sorry, I might be wrong. I'll just point that out.
Most probably you're right, yes.
In that event, if the writ rules incorporate the CPC to the extent it can be done, then the CPC is the fallback. If the CPC is the fallback, there are, though it's not a plaint, but it is the final, a final relief sought for, and then, we ask for interim reliefs in the nature of CAN or interim applications. And why I'm saying this, I am saying the original prayer and the prayer made in the GA has got no relationship.
If you say that CPC is applicable and not the principles, Mr. Rai, please answer this question, whether the constitution can be curtailed or truncated by any subordinate legislation. Every legislation in the country is subordinate to the constitution.
But I never said that.
CPC cannot curtail Article 226 jurisdiction, Mr. Rai. Can rules framed by the high courts apply the CPC by this oblique process?
But that is what your lordships have.
Principles we can appreciate.
Your lordships have incorporated. I am relying on that.
You have incorporated on the administrative side, you have incorporated. That's not a judicial order.
That's not a judicial order. Your lordships can definitely hold otherwise.
We have the power. The High Court.
Your lordships have full power. There is no
dispute. The full court has power to, High Court as in High Court, not the Chief Justice.
No.
High Court has power to make its rules of procedure.
Yes.
But my question to you is whether the rules of procedure can override the Article 226 where the statute.
No, I'm not saying that, Even in this
judgment, say that the
CPC
has been body lifted to 226 jurisdiction. Principles.
It says to the extent it can be affected by the
language is to be seen.
I just pointed out. Rule 53.
This is the appellate side rules, writ rules. Rules আমাদের আছে? Appellate side rules কোথাও আছে? থাকা উচিত তো, writ rules তার মধ্যে পাওয়া যায়।
And kindly does not take me that way. I'm never saying, your lordship, this is a special jurisdiction, 226. So your lordship will always have the power. But the point is, how much your lordships will be using that power.
My question was whether the CPC is applicable or the principles of CPC. That is what we.
That would appear
if
from
the CPC is applicable, then that Supreme Court judgment is squarely, fully applicable.
And the rules will have
Section 100 and all this.
The rules, I might be wrong also,
Ask your junior to just. Is it available in the internet?
Get it,
Well, let us continue in a minute. Yes, yes, just find it.
I have got Mr. Mukherjee. He's been very gracious to show me
and just give.
Yes, it says as far as it is applicable, save and accept. And may I just read the Rule 53. Save and accept as provided by the rules and subject thereto. The provisions of the CPC in regards to suits shall be followed. As far as it can be made applicable in all proceedings under Article 226. And nothing in these rules shall be deemed to limit or otherwise afflict the inherent power, as I said, of this court to make such orders I think necessary for the ends of justice to prevent the abuse of the process of the courts. So I said, your lordship always have the powers.
Yes.
But it incorporates the CPC.
Right.
So, my lord, it gives full powers. It is upon your lordship. Now the point is, my lord, whether this is covered or not covered. And I am showing, my lord, this judgment also refers to that yes, it can be done, but it should not be done. My lord, this is that, and my lord, now only on the point of violation of natural justice in the prejudice test, my lord.
Yes.
So, and first judgment is well, paragraphs, patience, sir. Paragraphs 29 to 32, my lord. My lord, straight away take it, lordship 32, my lord. Your lordship permits, my lord.
Yes, that's it.
The basic concept is fair play in action, administrative, judicial, or quasi-judicial. The concept of fair play in action must depend on the particular list, if there be any, between the parties. If the credibility of a person who has testified or given some information is in doubt, or if the version of the statement of the person who has testified is in dispute, right of cross-examination must inevitably form part of fair play in action, but where there is no list regarding the facts, but certain explanation of the circumstances, there is no requirement of cross-examination to be fulfilled to justify fair play in action. When on the questions of fact there was no dispute, no real prejudice has been caused to a party agreed by an order, by absence of any formal opportunity of cross-examination per se does not invalidate or vitiate the decision arrived at fairly. So the prejudicial test is, my lord, whether the complaint of violation of natural justice has caused real prejudice to the person complaining of the same. Here I have said, my lord, tried to show your lordship, my lord, over so many years, which might have cut both ways now, my lord, they have had immense opportunities to give their case, make out their case. Hearing also, they said, look, whatever we have got, now you go proceed. If you have to proceed, you proceed, subject to my appeal. There's the last letter of Mr. Ganguly, the advocates of the petitioner. So, this is what I was referring to in the last judgment. It echoes more or less the same, but it's very decent. So I'll just rely on it, and those would be my submission. And this is 2021 19 Supreme Court cases 706. আমার একটা কপি দাও প্যারাগ্রাফটা বলো পেট কভার দাও না একখানা অত অনুবাদ বলে এত পড়বো এখন জজ সাহেবকে দেখতে পাচ্ছ জজ সাহেবরা বার্ডেন হয়ে গেছে সবাই 26 31 36 My lord, may I just take your lordship to paragraph 26 first. Internal page 732, my lord.
Yes.
It may be added that every case in which a citizen or person knocks at the door of the writ court for breach of his or its fundamental rights is a matter which contains a public law element, as opposed to a case which is concerned only with breach of contract and damages flowing therefrom. Whenever a plea of breach of natural justice is made against the state, the said plea, if found sustainable, sounds in constitutional law as arbitrary state action which attracts the provisions of Article 14. The present case, therefore, a case which involves a public law element in that petitioner who knocked at the door of the writ court alleged breach of audi alteram partem rule, as the entire proceedings leading to cancellation of the tender, together with the cancellation itself, were done on an ex parte appraisal of the facts behind his back. Next paragraph. Then, my lord, kindly see paragraph 31.
Yes.
Rather, my lord, 29, my lord, 29 first and then 31. Both the learned senior advocates locked horns on the odi alteram partem part of natural justice. Dr. Singhvi argued that it is not an inflexible tool in the hands of the court, but must yield when no prejudice is caused, and where it would be an idle formality to set aside an order as all the facts on records are admitted facts to which nothing can be added or subtracted by the respondent number one. And Mr. Dwivedi on the other hand argued that this is a case of complete lack of natural justice. All orders having been passed behind the back of his client, as a result of which his client has been severely prejudiced. Then 31. In some of the early judgments of this court, non-observance of natural justice was said to be prejudice in itself to the persons affected, and proof of prejudice independent of proof of denial of natural justice were held to be unnecessary. The only exception to this is where on admitted or indisputable facts, only one conclusion is possible, and under the law, only one penalty is permissible. In such case, a court may not issue its writ to compel the observance of natural justice, not because it is not necessary to observe natural justice, because courts do not issue writs which are futile, and refers to certain judgments, my lord. Then, my lord, 31 degachi na. 31 degachi na. Then, my lord, kindly comes to, my lord, paragraph 36, my lord. What is important to note is that it is the court or tribunal which must determine whether or not prejudice has been caused, and not the authority on an expert appraisal of the facts. This is well explained in the later judgment and gives the my lord judgment. Then, my lord, kindly comes to, my lord, page 741. This is part of para, or rather it's para 37. State Bank of India, division bench of this court distinguished between adequate opportunity and no opportunity at all, and held that the prejudice exception operates more especially in the latter case. The judgment also speaks of procedural and substantive provisions of law which embody the principles of natural justice, which were infracted must lead to prejudice being caused to the litigant in order to afford him relief as follows. So, my lord, what I am saying, my lord, here, my lord, kindly vis-a-vis our case, my lord, opportunity has been given. It is not a case of no opportunity. If it's not a case of no opportunity, the prejudice has to be shown. What else they would have shown? What else they would have given us? Because, my lord, with humility, I say, my lord, whatever points they have taken vis-a-vis the final order, my lord, these are saying that the order is bad. Like it cannot be khate pate, it cannot be, these are not facts. And last, my lord, 42, my lord. The analysis, final analysis, my lord. 42.
We're relying on 40.
Is a flexible tool in the hands of the judiciary to reach out in fit cases to remedy injustice. The breach of Audi-Walton rule cannot by itself without more lead to a conclusion that prejudice is thereby caused. Where procedural and substantive provisions of law embody the principles of natural justice, the infraction per se does not lead to invalidity of the orders passed. Here again, prejudice must be caused to the litigant, except in the case of a mandatory provision of law which is conceived not only in individual interest but also in the public interest. No prejudice caused to the person complaining of the breach of natural justice where such person does not dispute the case against him or it. This can only happen by reason of estoppel, acquisition of waiver, by non-challenge or non-denial or admission of facts. In cases in which the court finds on fact that no real prejudice can therefore be said to have been caused to the persons complaining of the breach of natural justice. But pausing here for a moment, my lord, I will also put in my notes, my lord, where 3 times, my lord, they have been told that you are giving me these documents are not there, kindly give your answer. They give answers. Then they say, sir, the report is not there, the reasoning behind that, the entire
Give the page numbers of those.
I will give that, I'll give that. Then 42.14, in cases where facts can be stated to be admitted indisputable and only one conclusion possible, court does not pass futile orders and setting aside or
42.2 and 42.5.
Yes, but that is more or less
42.5 also.
Well, But giving my learned friend's clients a bit more, my lord, 42.5 is something which your lordship will only have to consider. That's a test on which your lordship will set. Whether, my lord, there is a mere apprehension, reasonable suspicion, my lord, that your lordship will obviously. I say it's not even an apprehension; it's an afterthought. It's an afterthought of my learned friend's client. Therefore, my lord, this does not apply. So these are my submissions. These are my submissions.
Yes.
A few minutes back, another judge told me all good things must come to an end. But so at least for me, this has now come to an end. My lord, may I kindly take your lordship's leave, my lord?
Yes.
I am very grateful. And he said that I was not completing because he was not here. Now he's here. Very grateful.
Yes.
My lord, Mr. Ray, my lord, has had the field, my lord, from 2023. My lord, I just checked, my lord, November 23 is when I addressed your lordship last. But my lord, I will, my lord, give my reply. My lord, my lord, it's impossible for everybody to remember, my lord.
You have till 2026, 2027.
No, I'll conclude, my lord. If not today, I didn't, my lord.
Definitely.
My lord, next Friday, my lord, I'll certainly, my lord, conclude.
Thank you. Yes.
Now, my lord, 3, my lord, preliminary submissions. In fact, my lord, today, my lord, it's actually 4, my lord, preliminary submissions have been made. My lord, apropos, my lord, these proceedings. My lord, the first is that, my lord, the relief that I've sought, my lord, in the GA, my lord, could have been an independent writ petition, but, my lord, cannot expand the scope of, my lord, the present writ petition, and therefore should not be entertained. Second, my lord, a corollary of this is an interim relief is being sought, my lord, which is beyond, my lord, the scope of the main writ petition. So, my lord, I put that aside, my lord, as one point. Second, my lord, is that, my lord, the writ petition raises disputed questions of fact in a complex matter. My lord, the passage has also been quoted. My lord, it's a complex matter, raises disputed questions of fact, and therefore the writ court should not entertain the writ petition. Third is, my lord, that the entire subject matter, my lord, of the application and the writ petition, my lord, is, my lord, a contractual dispute, and therefore the court should not, my lord, entertain the writ petition. And lastly, my lord, is what was argued with, my lord, by referring to also, it was argued earlier also by referring to 2 cases, my lord, is the prejudice test. My lord, the breach of the principles of natural justice which we allege, my lord, there was, my lord, actually no prejudice caused.
You're given several opportunities and you...
My lord, not even one. My lord, till, my lord, the matter came to the appeal court and we responded with a letter which they say they considered, and not one single point raised in the letter has been considered in the impugned order. I'll show that. Demonstrate that. Before that, nothing. Now, my lord,
you want to distinguish between an opportunity to produce your documents and a specific charge that you are guilty of this. Do you want to have a distinction on, because they gave you several letters over years?
So, my lord, please produce these documents which we
Asking
produced.
for documents, yes.
Which we produced. But, my lord,
and you said that the rest of the documents I don't have, or I
not the same documents. We said we've already given it to you. After 14 years, again they're asking for it.
Yes.
My lord, the documents were given in 2002. And, my lord, I showed from the list of dates, my lord, from 2004. My lord, there's no communication till that order is passed in the writ.
But do you say that they had to give an additional, opportunity to meet the...
Yes, because I must know what my charges against
charges, allegations.
Correct. And, my lord, I cited 2 cases, my lord, on show cause notices.
Yes.
My lord, they are not, my lord, disciplinary, my lord, proceedings or anything. The cases I cited. Because, my lord, here I'm being visited with penal consequences. There's a penalty as well. Now, my lord, important thing now, my lord, apropos the first point, my lord, whether, my lord, the writ, my lord, it's beyond writ, etc., etc. Now, my lord, kindly take, my lord, the writ petition once, which is before your lordships. My lord,
Writ petition
number 305 of 2022.
Very good.
My lord, the GA is separate, my lord, there's a writ petition and, my lord, a supplementary affidavit. Kindly take the supplementary affidavit. There's a supplementary affidavit to the writ petition.
The GL writ.
এরকম আছে পাতলা একটা একদম পাতলা এটা ডেট হলো আপনার 21st January 2022 কপি আছে
আমাকে দিয়ে দিয়েছে
get the file and affidavit to the main matter.
Yes.
Not when Mantha passed the order.
দেখো আশেপাশে অন্য কোনো ফাইলের সঙ্গে নেই তো
পেয়েছেন
এগুলোর মধ্যে এটা এই ফাইল না
Do you have a copy?
এটা আর কোনো ফাইল নেই এইটুকুনি
এটা দিয়ে দাও
দিয়ে বলুন
তাড়াতাড়ি তোমার মুভে এটা তোমার তো মার্ক আছে না
এগুলো কি দেয়
Well, the good thing is I find everybody is marked.
এইগুলো
Well, it's a very slim affidavit.
এরকম
The only I checked if anybody has copies.
অরিজিনাল
No, they have copies and they're all marked. So I'm very happy that everybody's read. But I am. But
Banerjee has an unmarked.
yes, so
That's a status symbol.
yes,
We don't do so.
yes. I have, if your lordship permits.
But you will require that.
No, I have.
No,
I have.
Ankur ওটা দিয়ে দাও
Page.
মিস্টার মুখার্জি যে দিলেন উনি পেয়ে গেলেন Yes. But there is not much scope of marking.
No, it's just one document, my lord,
Yes.
which is relevant for the relief. My lord, before I place, my lord, my lord, paragraphs, my lord, I'm just making, my lord, a point here,
Yes.
my lord, as to the scope of the writ petition, my lord, which is very important. My lord, paragraphs, my lord, 10 to 20, pages 4 to 7, my lord, rely on, my lord, documents, my lord, correspondence exchange between the Calcutta Stock Exchange and, my lord, the writ petitioners from, my lord, 2004, which relates to this, give me this document, give me that document, etc. Now, my lord, I have given your lordship the list of dates. My lord, kindly keep that because that will, my lord, side by, because that will, my lord, put, my lord, the kindly take para 16 once, my lord, just para 16. Certain date of performance.
Para 16 is the yes.
Page 6, my lord, of the writ petition. My lord, while this inspection, my lord, is going on, I'm just showing your lordships, my lord, that the scope of the writ is what it was.
Yes, yes.
Nothing has changed. My lord, to deny me the relief which they have claimed, which we have claimed in the writ petition, this order has been passed. My lord, that is, there was no affidavit filed to the writ petition till the matter was sent back. Order was set aside and sent back. Then, my lord, the main affidavit came, where the defense is, we have this order, so we cannot refund any money back to you. So, my lord, the order is operating at a defense to my claim and prayer made in the writ petition. No enlargement of scope or anything. In fact, we didn't even know there was an investigation or anything on till, my lord, the submission was made before, my lord, the learned single judge at the time of the first disposal, my lord, of the writ petition. Now kindly have a look at, my lord, paragraph 16.
Yes.
My lord, the petitioner number 1, my lord, page 6,
Yes,
duly replied paragraph by paragraph to each and every allegation contained in the letter dated so-and-so, vide its letter. From the said reply, it is clear that the CSE had failed to appreciate the fact that petitioner was member of multiple stock exchanges and had wrongly interpreted the transactions done on behalf of clients on other exchanges as off-market transactions. Because one of the allegations is you have entered into off-market transactions. And the second is, my lord, synchronized trading.
Yes.
These are the two allegations.
Yes.
The respondent number 1, faced with strong replies given by the petitioner number 1, resorted to procrastinating tactics and asked the petitioner number 1 by letter of 23rd March to again appear before inspection team with all relevant documents. It is a writ petition. Writ petition put. It was apparent that CSC was resorting to roving and fishing inquiries without any basis for ulterior motives. The petitioner thereafter wrote to Calcutta Stock Exchange on 30th March 2004 seeking termination of their trading membership and directed Calcutta Stock Exchange to do the following: deactivate trading terminal, deregister membership, refund capital adequacy deposits of petitioner number 1 lying with Calcutta Stock. Copy of letter issued is annexed here to and marked. So, my lord, we said we are not going to trade on your terminal. You please terminate our membership. Please return the whatever capital adequacy ratio of money which is deposited with you. Then, my lord, kindly come straight away, my lord, to para 20. The respondent number 1, in a most arbitrary action and in gross abuse of process of law, by its letter dated 6th May, took an irrational stand that such request for cessation can only be granted on completion of inspection of records, and therefore refused to consider the prayer of company while returning the original SEBI registration imposed following preconditions for cessation of membership petitioner number 1 from exchange, surrender and so, copy of the said letter. So, my lord, they said, look, our inspection has to be completed, then only will we. And this is, my lord, your lordship will find from the list of dates that, my lord, the last set of correspondence on this. Now, my lord, kindly come to, my lord, paragraph, my lord, 31. My lord, this was reactivated, my lord, in 2013. The correspondence. My lord, because of us, my lord, filing writ petitions and, my lord, a civil suit complaining of them, my lord, withholding, my lord, this money and not, my lord, terminating my membership. So, my lord, according to us, my lord, there was, my lord, a settlement to the effect, my lord, you withdraw these cases and we'll do the needful. And that's pleaded. Kindly see para 31. Petitioner number 1 withdrew the cases filed at them with regard to surrender and resubmitted the documents for surrender along with its previously filed letter dated so-and-so and on its annexures vide a fresh letter. Petitioner vide submitted the processing fees for etc. Then, my lord, despite confirmation, my lord, matter remained, my lord, unresolved, completely unresolved. Then, my lord, what did they do? They decided, my lord, para 33, later on, under repeated reminders, the Calcutta Stock Exchange credited the interest of deposit lying with them to the credit of petitioner. So, my lord, they accepted, well, money belongs to me. So, whatever interest is being accrued, my lord, is, my lord, being paid. Now, kindly have a look at, my lord, our prayers. My lord, which is, my lord, at page 23, my lord.
Yes.
So, my lord, as long as I remain a member, a certain amount, my lord, has to be deposited as security deposit. Now, my lord, there was a notification by SEBI reducing the amount that we had to keep in deposit. So, my lord, we said the excess, therefore, is, my lord, 39 lakhs 4,332. That was our prayer. You please refund this. And that your lordship will find, my lord, in the supplementary affidavit, my lord, page 20, P28, my lord, the SEBI circular of 19th December 2012.
Page 8.
Yes, my lord, page 8.
Yes.
My lord, which says, my lord, how much, my lord, is to be maintained. This was the base minimum capital stock for stockbrokers. And on this basis, we indicated to them that it's only 4 lakhs which you can have.
This was the premise for your
The writ.
claim for refund.
Correct.
All right.
Now, my lord, so, my lord, how do they stop my refund?
Yes.
By saying, oh, there's a penalty of so and 60 lakhs against you. We have a finding of loss having been caused to us. And these are findings after the filing of the writ. Now, my lord, in the writ petition, when it came up for hearing, kindly have a look at the order, my lord, which was passed, which is in the GA, my lord. Kindly come to page 48. Volume 1, my lord, volume 1.
Yes.
Kindly have a look. The writ petitioner is aggrieved by the Calcutta Stock Exchange, withholding a sum of 38 lakhs and odd towards security and other deposits. The petitioner is a member of Stock Exchange. For acts and omissions inter alia alleged against the petitioner, the CSE and Securities Exchange Board of India, being the respond number 3, commenced investigation. SEBI subsequently found that no statutory dues are payable. Insofar as investigation for violation of rules of stock exchange and provisions is concerned, the matter remained without closure. The CSE continued to hold, albeit in an interest-bearing deposit account, the sum of rupees 38 lakhs. This court is of the view that Calcutta Stock Exchange Limited should take a final call on the investigation that the claim is still pending against the petitioner without prejudice to its rights and content. Let such final decision be taken within a period of 45 days. In the meantime, etc., needless to mention, in the event CSE finds in its final order that the petitioner is not guilty of violation of any of the provisions of the exchange, or that continuation of a proceeding is no longer feasible, a suitable decision to that effect and deposit together with accrued interest shall be refunded. Petitioner shall cooperate, etc. Since no affidavit has been called for, allegations in the petition are deemed not. So no affidavit filed. First day, my lord, writ petition gets disposed of. CSE says, well, we are conducting an investigation and this is what it is. My lord, we say, my lord, there is no investigation, we go up on appeal. Now, my lord, the division bench order, my lord, answers the first 2 questions. Kindly have a look at it. That's, my lord, volume 2. My lord, page 145. My lord, kindly take paragraph 2, my lord, page 146.
Yes.
My lord, I'll just place this. The facts in nutshell are that the appellant had filed the writ petition with the plea that the appellant is registered with SEBI as its top broker and had carried on business as a member of Respond Number 1, as also other stock exchanges, namely so and so. Further, please raise that CSE has been asked by SEBI to initiate the process of compulsorily exit of the company as a stock exchange, which CSE is litigating, and that Respond Number 1 was demanding inspection of books records for the period 1st April to 9th May 2002. Therefore, exchange of communication took place. As per the stand of the appellant, following the applicable norm, the appellant was maintaining 50 lakhs as base minimum capital in the fixed deposit, and that as per applicable norm, stock exchange is not entitled to appropriate the interest accruing. However, with a notice dated so and so, Respond Number 1 instructed the bank to stop crediting any interest to the account of appellant number 1. Earlier round of litigation took place between the parties, and per the plea in the petition, sum of 39 lakhs is lying in deposit. Request of the appellant to release the funds in excess of so-and-so was not responded to by respondent number 1, and the appellant's request to surrender was also. Hence, he filed writ petition claiming this. Learned single judge by the order dated 2nd February 2022 has disposed, directing, etc. Now, my lord, submission raised by the learned counsel for the appellant is that no investigation, kindly note this one, no investigation against the appellant is pending, and in this regard, he has referred to the communications dated 6th May 2004, 29th April 2013, 30th April 2013, 7 June 2013, and 18 June, and has submitted that only inspection is to be done, and as desired by respondent number 1, miscellaneous case number has been withdrawn. Therefore, the respondent number 1 has no option but to process the pending application. He has also submitted that since no affidavits were called for by the respondent, therefore real picture has not come on record, and hence the matter be remanded back to the learned single judge for fresh adjudication. Plea of the respondent is that investigation and inspection of the books of accounts and record is required to be done in connection, kindly note, with a fraud. Hence, no error has been committed with the learned single judge in passing. Having heard the learned counsel for the parties and on perusal of the record, it is noticed that the writ petition has been disposed of without calling affidavits from the respondent. Heavy reliance has been placed by the appellants on the communication of 30th April 2013 sent by respondent number 1 to the appellant to the effect that surrender of membership will be proceeded after legal case is settled. Similar communications dated 17 June, 18 June were sent. Respondent vide communication dated 19 was informed about the withdrawal of the pending arising out of title. Hence, the plea of the appellant, the respondents are bound by their earlier stand. Instead of restraint, my lord, it should be stand. Needs to be examined. Now, my lord, kindly see what happens. Therefore, we set aside the order under challenge and request the learned single judge to decide the issue afresh. My lord, the issue is whether I'm entitled to get this money back or not. Then, my lord, meanwhile, 45 days period fixed by the learned single judge to take final decision has expired. Therefore, the final decision, if any, taken meanwhile, can also be placed challenged before the learned single judge. My lord, this is an order, inter parties binding, my lord, on my lord, the parties. My lord, irrespective of whether it's right or wrong, my lord, whether, kindly have a look at the last sentence now. Such a final decision will be subject to the final outcome of the petition. The appeal is accordingly disposed of. So, my lord, it's this writ petition where, my lord, I make this challenge. That fact will be taken into consideration, my lord, and on that basis, my lord, the final relief, my lord, final decision rather, would be made, my lord, in, my lord, the writ petition. So, my lord, there is no expanding the scope, my lord, of the writ petition. These documents, my lord, are all mentioned, my lord, in the writ petition. Basically, one of the grounds, my lord, of challenge was, look, we agreed we had an agreement that after the first refusal, that after we withdraw the pending cases, you will process my application. They don't even do that. Then that's when we came. When we moved, they said, oh, there is an investigation pending. And my lord, the learned judge passes the order. My lord, there was nothing on record to suggest that there was an investigation. On that basis, we went up on appeal. Our stand even then was, my lord, there's no investigation pending. My lord, the division bench sent, my lord, the matter back, saying the main writ petition will be decided afresh. My lord, if a decision has come, because 45 days, my lord, was the time period prescribed by the learned single judge. In the meanwhile, my lord, we'll have, my lord, the right to challenge it before, my lord, the learned judge. And the decision in the writ will be, my lord, the final decision after taking into account all this. So, my lord, there is, my lord, by reason of this order, my lord, first, there is no expanding of the writ petition. Second, my lord, there is no, my lord, interim relief being sought, my lord, which is beyond, my lord, the writ. As it fell from your lordship, my lord, your lordship deciding the writ, taking, my lord, these matters into consideration because of the division bench judgment. So, my lord, this point, my lord, if I may, my lord, indicate, my lord, Bachaj Nahaj, my lord, that's I think 2008-17 SEC, my lord, which was, my lord, cited, and Jessup's case.
Yes.
My lord, both, my lord, really have no application. Not at all, because here there is a division bench judgment binding on the parties. Parties have accepted it. Nobody has challenged that decision, which has said, my lord, that the writ court will decide this issue in that writ petition. And here, my lord,
Yes.
sorry, my lord, my lord, just one sentence.
Yes, yes,
my lord, most importantly,
yes.
my lord, as it fell from your lordships, my lord, they now got the opportunity when the matter came back to file an affidavit to the main writ as well as the GA. And my lord, that is what, my lord, full opportunity is given to them, my lord, to deal with, my lord, the case. My lord, when I show you, my lord, 2 or 3 matters, my learned friend has not touched at all. And I understand, because there's no answer. There's no answer.
So we'll continue next Friday.
Yes, my lord. My lord, I believe, my lord, there's another matter which is Kessel's. Kessel's, my lord, I think.
Cases is there, yes.
No, I'll finish it.
Cases is going on. Mr. Shindra is.
Yes, my lord.
That the other side, we don't know whether they'll start. He will conclude, probably should conclude by the first half, because he was citing judgments. So we'll keep it on the.
I kindly keep
if
it
you're
on
in
the, if not,
difficulty,
my lord,
yes,
the next
no
Friday.
difficulty. No, if you're in difficulty, or
No, my lord, the only thing I'm apprehensive about, as it fell from your lordship in the other matter, my lord, the
bulk.
yes, my lord, that it should not go over, my lord, to, my lord, another change of determination, or
That
my
is
lord,
what
that's
we
what
are
I'm.
always after.
So, my lord, I want to finish it, my lord. All the matters I have before your lordship, if possible.
No, in this matter, in the single bench matters, that won't be a problem.
Very well.
There is a problem in the division bench, because the combination changes.
Yes, correct.
I'll carry,
Yes.
like a Hindu, I carry the law with me. Heard in part for further hearing on December 5, 2025.
I'll forget it. The Banerjees made the appearance at the right time.
So here's it. No, I was here.
My lord no longer assists as much as he did when he was a junior.
No.
Now he, my lord, leaves it. Oh, you're there. I don't need to read anything. Then I have to brief him if I'm not.
Can't even protest on that. No. We'll take up the appellate service.
Oh, appellates. I'm sorry.
No need to sorry.
There's a 3:30, I think, resolution today. That's why.
Resolution is there, but
Yes,
I usually take up matters if
Yes,
both
yes.
sides are not. But জিজ্ঞেস করুন, mentioning আছে কিন্তু.
My
Yes.
lord, may I be allowed to mention one part head matter, my lord?
By me, single?
Yes.
Yeah, absolutely. Yes. পাঠার matter লিস্টে নেই কেন? One second. পাঠার matter তো সব লিস্টে দেওয়ার ইনস্ট্রাকশন। Are you sure it was marked as partnered?
Yes, my lord. My lord, the advocate on record has instructed me that it's.
Because I had given a specific instruction that all partnered matters should appear in the list. Then এইখানে দেখুন কল করুন রেকর্ডটা দেখুন partnered marking. Very well, we'll check up. দেখুন actually partnered আছে কিনা, marking আছে কিনা. By an order dated November 7, 2025, the appellants were directed to put in fresh requisites for service of notice of the appeal on the respondents within a fortnight from date. Whose sub next para. However, it transpires that no such steps have been taken by the appellant. Full stop. Next para. The office shall furnish a report within a week as to whether such fresh requisites have been put in by now pursuant to the order dated November 7, 2025. Full stop. The matter shall next be listed under the same heading on December 5, 2025. Next. অফিসকে পাঠিয়ে দেবেন, বলবেন একটা রিপোর্ট করে পাঠিয়ে দিতে আর জমা দিয়েছি। সেম, এক্স্যাক্টলি সেম। অফিসকে এগুলো বলবেন কিন্তু রিপোর্ট দিতে, তা নাহলে ওরা বুঝবে না, জানবে না। Incomplete report there. By an order dated September 11, 2025, a revised report was called for from the office regarding fresh service of notice being effected on the respondents. Full stop. The office report dated November 19, 2025 indicates that since rules were issued for substitution, there is no respondent left for copies to be served on. Full stop. However, the said report is incomplete. Full stop. The office shall furnish a comprehensive report as to the fate of the service regarding the two civil rules mentioned in the report dated November 19, 2025. অর্ধেক কাজ জানে না, বলবেন যে রুলগুলো রিপোর্ট দিতে, যা যা ম্যাটার আছে। দুটো সিভিল রুল ইস্যু হয়েছিল, ওরা বলে ছেড়ে দিয়েছে যে ওটা রুল ইস্যু হচ্ছে, ব্যাস রুলগুলো সলভ হয়েছে কিনা সেটা বলেছি আমি অর্ডার দিতে। আমার আজকে অর্ডারটা ভালো করে পড়ে দেন ওদের। The office report dated November 19, 2025, furnished pursuant to the direction dated September 11, 2025, indicates that the trial court records have not been issued as yet. Push up. A reminder has thereafter been issued on the concerned district judge with a memo number 2560-S dated November 19, 2025. Push up. Next para. The office shall furnish a further report as to the outcome of such. Now, it last line to the next para. However, at the time of call, none appears for either of the parties. Next para. Accordingly, as a last chance to the appellant to appear and argue the matter, let them same stand adjourned till December 5, 2025. Item number 5. This is the second occasion when none appears for the parties at the time of call. Push up. From the order dated November 14, 2025, it transpires that on the said date as well, none had appeared for either of the parties and the last chance was given to the appellant to argue the appeal. Push up. Since even today none appears, SA 892 of 1965 is dismissed for default without any orders to cost. Interim orders, if any, stand vacated. Item number 6. Exactly same order. Item number 7. Same. Item number 8 with 9. Same. appeals হবে plural.
Item number 10.
Same.
Item number 11.
যদি নর্মাল order আছে সেম।
Item number 12.
যদি নভেম্বর সেম। পরেরটা বোধহয় তাই সবকটা পুরো সিরিজটাই তো।
Item number 13.
একটু করে একবার দেখান তো। সেম।
Item number 14 to 19.
সেম appeals. Yes.
Lordship, I am appealing on behalf of the petitioner led by Mr. Raghunath Chakraborty. Lordship, on last occasion, we filed a written objection to seek certain documents from the alleged contemnant, Lordship, to ascertain whether there is actually been due compliance of this order of the court.
Yes, have you given the document?
We could not serve it because we have received it today morning. I'm handing over 13th November 2025, Your Lordship. There were certain, may I take the trouble of taking Your Lordship to page number 3, the document which I have handed over right now.
This
Which-
is their communication.
No, this is
Their
this what we
communication?
have received.
No, they're acha, very well. This is acha.
What?
This is your authority.
Yes, my authority,
Yes.
which says that we have disbursed everything.
So you
This
please
is
give a
kindly
copy.
sees page.
Give a copy to them.
Give a
then,
copy to them.
Learned.
Lordship, may I be permitted to join, my lord, subject to the
Yes,
leave of
Mr. Chakraborty, they are giving the copies now.
Yes, my lord, on the last occasion, my lord, we pray for
We remember,
service
we
to-
remember, we remember, Mr. Chakraborty, please don't
Lords,
repeat
lords,
the entire thing.
lords.
Learned AGP appearing for the alleged contemner hands over certain documents. However, since the documents, since the said copies of the documents were received only this morning, it is submitted that the alleged contemner could not hand those over to the learned advocate for the petitioners. Full stop. You have given.
Yes.
Full stop. As such, such copies are handed over here and now to the learned advocate for the petitioners. Full stop. In order for the petitioners to take instructions on the same, let the matter stand adjourned till December 5, 2020. Mr. Chakraborty, go through the record documents and just check out.
I hope
Deeply obliged. Deeply obliged. Deeply obliged.
The alleged contemner hopes and trusts that this will satisfy you and your client.
Deeply obliged, my lord.
Full, Your Lordship.
Yes. You are appearing? Oh, yeah, previous. আজ ইয়ে আছে না রেজলিউশন আছে কোন অর্ডার রেকর্ড করতে না আচ্ছা একটা অর্ডার রেকর্ড করুন none appears for the parties let the matter stand adjourned for the day.
Item number 22 to 24.
Same order. None appears for the parties. Adjourned for the day.
Item number 25.
Same.
Item number 26.
Same order.
Item number 27.
Same.
Item number 27 to 20.
Ah,
27 to 30, 34.
27 to 33, Lordship can recall that Bangla Shosho Bima matter. The farmers.
7 হবে তো। কি ডাকছেন?
No.
27 to 37 বোর্ডে ডাক। Yes, Mr. Galib.
My lord, Lordship can recalls, my lord, Mr. Abhutosh
So
Mujumdar.
that's yes.
Bang Shosho Bima. The bank did not transmit the premium on time to the this insurance company. So that's why the coverage was not disbursed to the
State was to be served or
I
something.
state I
But
appear for 28 and 31
State.
for the state.
Why not in the other matters?
No, I have been given these two matters only, my lord.
32 and 33.
And Mr.
আচ্ছা আচ্ছা।
Mr. Abhutosh Mujumdar is for the recalling applicant. That is it.
So-
Recalling is by the insurance. And Parna Roy Chaudhary is for the bank.
Bank.
So kindly, my lord, stand over.
Yes. Since the review applicant and the bank are not represented today, let the matter stand adjourned for the day.
My lordship.
Let's come back next Friday.
Okay.
Grateful, Your Lordship.
Item number 38.
My
What is
lord,
your- Give your name.
my name is S.K. Humayun Reza, my lord.
I know your name. Give it to my officer.
Yes, my lord.
Give it in a slip of paper so that your name can be recorded.
I'm appearing for the respondent.
You are in 38.
No, Your Lordship.
37 years, give your name.
Item number 39.
ওহো হ্যাঁ, আগের অর্ডারটা বললাম ব্যাংক ইজ নট রিপ্রেজেন্ট ব্যাংকটা বাদ যাবে সিন্স দে রিভিউ অ্যাপ্লিকেন্ট হবে 38 years 38 38 ডাকলেন না না পেজ
Item number 39.
My lord, in 39, my lord, I appear for the opposite parties, my lord.
opposite party none appears for the petitioner although the for the alleged contemner that means
Yes, my lord.
Correct, although the alleged contemner is represented through counsel Pushap, let the matter stand adjourned for the day. Whoever is appearing with you, Mr. They just give the total, all the names.
Yes, grateful, my lord, grateful.
Yes. Next.
Item number 40.
Lord, I appear for the petition. Lord, we had filed our notes. That is, this is that PMLA specially assigned matter.
Yes.
Mr. Chaudhary was appearing. Mr.
They were to file their notes.
I believe there was a direction, my lord.
দেখি অর্ডার ফাইলটা কোথায় উত্তলা কম্পার একটু হেল্প করো ওনাকে উনি পারবেন একা ওটা দাঁড়িয়ে আছো
17513.
অর্ডার শিটটা হলেই আমার হবে এখন আবার
I was trying to download the order. There's some problem with the connection. Otherwise, I would have shown your lordship the last order. Hey,
অবস্থা উকিলবাবু বলে দিচ্ছেন
I believe
yes, they
Mr.
were
Banerjee
to advance oral arguments as well as to come prepared with their notes.
their notes.
Today there's a
I believe Mr. Kaushik Banerjee is appearing online. I can see his name.
Now, Kaushik Banerjee's for respondent was 4 to 6.
4 to 6.
ED was to
Mr. Chakraborty.
Since the since the enforcement directorate is not present today, although the petitioners are represented through counsel, and it is now for the enforcement directorate to file their brief written notes of arguments as well as advance oral arguments, let the matter stand adjourned for the day.
Grateful.
Please give your name.
Absolutely.
I mean, whoever is appearing. Thank you.